All right, folks, I'm going to call the meeting to order. I do hear some shuffling of papers and whatnot, so could I ask you to mute yourself if you're not speaking, so that sound doesn't bleed through? Thank you. Um, Today is Thursday, February 25th, 2021. This is a meeting of the Town of Bourne Planning Board. This meeting will be broadcast live on Bourne TV. All items within the meeting agenda are subject to deliberation and votes by the planning board. Um, Just for the record, I'm going to indicate the members of the planning board who are present and participating remotely. I have Jean Azarovitz, Elizabeth Brown, Sandra Goldstein, David O'Connor, John Carroll, and Louis Gallo is indicated as Louis by his name. So Louis, the title for Louis is Louis Gallo. Dan Doucette, Stephen Stroney, alternate William Meyer is present, as well as member Elmer Clegg. The first item on the agenda, item number 1, is a request for bond release relative to 1379 Route 28A. Katomet. This is a paving and land. This is for a bond that was originally $10,000 held for the paving and landscaping until that's complete. This was a project that came before the board prior to every board member being on the board except for Mr. Doucette. And I've discussed this project with Mr. Doucette, what needs to be done to get the bond released, and Mr. Doucette is going to work with the current owner of the property in order to get the paving and the landscaping done, completed, checked out, with an eye towards releasing that bond. So there's not going to be any action on this until Mr. Doucette has the opportunity to make his site visit, connect with the owner, and then report back to the board. Ultimately, we'll need proof that the paving and landscaping are done in substantial compliance with what the special permit originally called for. And at that point, an as-built will be submitted, and ultimately the bond will be released, assuming everything's done to the satisfaction of the board. So that's agenda item number 1. Doesn't require any action. Just want to bring the board up to speed on that particular matter. Agenda item number 2, public hearing for court remand of supportive finding number 11-2019. This matter was continued from 1/28/21. This is ERS Realty Trust, property located at 183 Shore Road in Bourne. Can I remind you to mute yourself if you're not speaking? For further consideration, including the reasoning and basis of findings in support of the special permit. On this matter, I have consulted with town council, and I'm going to read the letter into the record that I received via email today from Robert Troy, who is town council for the town of Bourne. Chair Stroney, tonight's hearing in the above referenced matter is scheduled pursuant to an order from a justice of the land court. It is important to recognize that the land court has jurisdiction over all of these issues raised in this litigation, and that the planning board has authority to proceed only as directed by the land court justice. Accordingly, out of deference and respect to the land court, I respectfully request that the planning board continue this matter for a time period of not less than 30 days to permit the parties to file a status report with the land court justice informing the court of the changed circumstances. The parties will also be afforded the opportunity to file for any relief that they deem appropriate with the land court. Until the land court dismisses the litigation or takes other action within its jurisdictional authority, the Bourne Planning Board must await the determination of the land court as to how the planning board should proceed. Therefore, I request the planning board to continue the hearing scheduled for tonight for a period of not less than 30 days. Thank you, Robert S. Troy, Town Council. Our next meeting that is at least 30 days out would be April 8th, 2021. Is there a motion to continue this matter till April 8th, 2021?
Mr. Chairman, this is Michael Maurizio. I represent the abutters.
Hold on,
And the
Mr.
plank-
Hold on, Mr.
Point
Maurizio.
of order, a point of order, Mr. Chairman. This is an adjudicatory hearing, which I assume you have now reopened. It's been opened, but you've now continued since the last session. My clients are a party in interest. They are the plaintiffs in the litigation. This is an adjudicatory hearing that's affecting their real property interests. You cannot unilaterally, as I said today in emails that I circulated to town council, and you were on that email chain because town council put you on that email chain. Interestingly, none of the other board members were on that email chain. And in that email chain, I made it crystal clear that we are a party in interest. You cannot do what you've just presented as a motion. And in fact, the court's order is very, very different than what town council just referenced. And I think this board needs to read the order before it takes the vote that you're suggesting, which is very much in violation of that order. I was counsel before the land court. Your town council was present before the land court, and so was the markets council. And I made the obvious motion to the judge that your original supportive finding was invalid as a matter of law within the four corners of that document. And I said to the court, one of the reasons being that there was absolutely no evidence submitted that it was a legal non-conforming use, which was capable of being expanded. The court looked at what I said, looked at your order, and turned to your attorney and to the attorney for the market and said, what do you have to say in response? And they had no substantive response back. So I said to the court, and the court agreed, and the court put it in its order. For judicial economy, the court remanded the proceedings back to this board to conduct a proper hearing where you would, number one, ask the market to introduce evidence that it is a legal non-conforming use. Absent evidence to that requirement, which is their burden to prove, this whole proceeding is over. The prior supportive finding is invalid and has to be vacated. If somehow the market was to provide evidence that it is a legal non-conforming use, then you go to the proper standards for issuing what is in effect a special permit under your zoning bylaws. That's what the remand order says. And the remand order further says you shall conduct a hearing in accordance with Chapter 48, and the board shall issue a new final decision. Now, what's taken place, I understand, is the market has withdrawn its request for the permit. It intends not to pursue the project, which means there's no longer an issue in controversy. There's no longer an application before the board. There is no evidence still before the board that this is a legal non-conforming use. It is still an illegal non-conforming use. And so consistent with the board's order, the court's order, this board needs to render a final decision. There being no controversy, there's no basis to extend this public hearing any further. We object to that, as I did repeatedly today and prior. And the only option for this board to do is to rescind, revoke, and nullify the 2019 special permit. You have no applicant, you have no controversy, the matter is over with. If this board doesn't do that, you're acting contrary to the court's order. You're acting in violation of my client's rights, including their constitutional rights, and we'll have to take it up. Yes, we'll go back to the court, but we will seek damages in accordance with the Zoning Act for bad faith action and for breach of the court's order, for contempt of the court's order. Now, we don't want to do that. As we said from the beginning, we don't want to knock this market out of business. 1 month ago today, I circulated a proposed settlement agreement to council and to this planning board's administrator. And I specifically said in that email and in my cover letter that my submission was to be part of this public record, shared with all the board members and the public. I still can't find this. We proposed was we would allow the market to build its 1,200 square foot expansion with certain other conditions that
I'm
are
going to
entirely,
object.
frankly, consistent with the
Okay.
zoning
Settlement
bylaw.
discussions should not be discussed.
That-
It's a pending litigation. For him to be discussing
That-
settlement discussions is inappropriate.
Okay,
If I may be able to make this
is
very
not
easy and
litigation.
simple.
This is-
hold on. Mr. Attorney Maurizio, I'm going to let Attorney Troyer make his point, and then I'm going to make a ruling. Go ahead, Mr. Attorney Troyer.
First off, hi, it's Doug Troyer. I have been retained to represent ERS Realty in this matter. I believe that, and as we had submitted, there was a letter, I don't think it's been on the record yet, but my client has officially submitted a letter withdrawing its application for a supportive finding without prejudice, as the trust no longer seeks to proceed with the project at this time. My position is kind of similar to what this is a procedural technicality that we're dealing with right here. And my read of the land court's remand order is that it was sent back to the planning board for further consideration of the application to include reasoning and explain the basis for the findings supporting the issuance of the special permit. And that the board notice and conduct a public hearing and then ultimately make a decision. In essence, the land court remanded this matter back to this board to reopen the public hearing in order to make additional findings. And by doing that, you've reopened it. We, as the applicant, based on the dispute, have made a determination at this time not to proceed with this project. Unfortunately, we're unable to come to terms, and we are looking to basically withdraw the application at this time. In our position, by doing that with the board and making that request to the board to allow us to withdraw without prejudice, this board then can basically make a decision nullifying the original decision because it was in essence remanded back to you for further considerations. By us withdrawing it, it's a nullity. And having this board basically find that the applicant on remand has before the close of the public hearing has basically withdrawn its application. In essence, that brings the original decision a nullity. So, in order to avoid having contempt actions being brought against this board and basically the allegations which are being alleged, I think it's a simple procedural technicality. Town council obviously has a different position, and this board is obligated to opine with Mr. Troy. But I did want to indicate to you that our position is this is a procedural technicality. Otherwise, we have to go back to the land court to basically inform the land court that we have withdrawn. And most likely, the land court's going to send it back to you to basically accept our withdrawal and nullify the decision. We're just trying to, I think, at the end of the day, cut that process out.
Okay.
But I do understand Mr. Troy's position as well. But I did want to indicate to you that that's the procedural path that we think is also appropriate, and we're up whichever way the board finds is the best way to proceed. We're more than happy to do it to make it as easy as possible.
Okay, thank you very much. Appreciate that, Counselor. The two of you are very zealous advocates for your clients. I appreciate that. You're very well prepared. But town council has advised us to continue this matter, and this board is not going to take action that is not in accordance with the legal advice that town council has given us. So that being said,
Your board hasn't even
there a mo-
voted.
thank you. Is there a motion to continue the matter till April 8th, 2021?
So moved.
Is there a second?
Okay.
Second. Is there any discussion on the motion from just the board? Okay, if you would unmute yourself so I can take a roll call vote. Ms. Zarovitz,
Yes.
Ms. Brown,
Yes.
Ms. Goldstein, Mr. O'Connor,
Yes.
Mr. Carroll,
Yes.
Mr. Gallo,
Yes.
Mr. Doucette,
Yes.
Mr. Clegg,
Yes.
Miss Goldstein,
Yes, I'm not sure I understand all these matters as thoroughly as the rest of you do. I'm not sure which way to go, but I'll
All right.
see.
Oh, you
I'll-
you just
I'm
voted,
not sure.
you just voted yes. You just voted yes.
Did I?
It sh- The chair votes yes. This matter is continued till April 8th, 2021. Thank you, gentlemen.
Thank you. Have a good evening.
Next agenda item number,
Mr. Chairman,
yeah,
before you leave that agenda item, is there a good reason why we, the board members, did not receive things like the settlement offer?
yeah, there is a good reason. And if you want to email me and ask that question, I will answer it.
Why
Thank-
doesn't it,
Thank
why
you, Mr.
is,
Clegg.
why doesn't it deserve an answer in public?
Thank you, Mr. Clegg. Agenda item number 3 is a public hearing for supportive finding number 10
Excuse me, Mr. Chairman, you cut me off and muted me.
I did because I made a ruling. When it comes to litigation, those are matters that are taken under special consideration. It's one of the reasons we can go into executive session. Communications between lawyers and parties are privileged and
I
confidential.
asked a simple procedural question.
No.
Why are you not sharing information that you have with the board?
You can ask that to town council, Mr. Clegg. That's your answer. Thank you.
Well, then, Chair Stroni, I want to ask also why we don't share amongst all 9 of us the information we need to have at our hand when we come to these meetings. These background discussions are important to us, and we don't just wait 2 weeks to study on this. We put a lot of time in between meetings, and we need to know what the others know, what you know. And so there's no reason why I can't imagine why you would not circulate information that applies to all of us. Thank you.
When it comes to, Ms. Carroll, when it comes to litigation, there are special circumstances involved. That's what I can tell you. Item number 3, public hearing for supportive finding number 10-2020, 1131 Sandwich Road, Sagamore, Michael Bilodeau to build an outside bar, including bathrooms. Is there somebody here on behalf of the applicant?
Yes,
Okay, the floor is yours.
so I'm Suzanne Bilodeau, wife of Michael Bilodeau, owner of the Sagamore Inn Restaurant. As everyone knows, COVID has decimated restaurants and everyone is looking for outside options. So we are trying to stay in business and give our customers a great opportunity to be able to dine outside and to feel comfortable doing it. And building this outside bar and having the bathrooms there does that.
Okay. Anything further, Ms. Bilodeau?
Not at this time.
Okay, Mr. Doucette, I believe you had this matter. Can we get your thoughts on it?
Yes, Mr. Chairman, the applicant is proposing to build a bathroom and an outdoor bar to support the functions of the outdoor seating in the rear of the Sagamore Inn. The inn was originally built back in 1900, and it was rebuilt after a fire in 1930. So it does have the pre-existing non-conforming. And it also, the inn was lawfully in existence before zoning was adopted in January 1950. The bathroom and the bar meet the zoning setbacks to the rear. And they're just requesting an extension of the alteration. And it would not, depending on the view of the board, will not be substantially more detrimental to the neighborhood than the existing non-conforming use.
Okay. Anything further, Mr. Doucette?
I would open up for discussion for the board or any questions or concerns, and then I have a,
Well, before we go to board members, let's see if there's anybody in the audience
Yeah.
that would like to weigh in before we take a look at it. So this is the Sagamore Inn. The address is 1131 Sandwich Road. Is there anybody in the audience or anybody who has dialed in that would like to make a comment relative to this project?
Yes, there is. My name is William Sullivan, 1107 Sandwich Road. I'm here with my wife, and we abut the Sagamore Inn, and we object to this particular project.
On what basis, Mr. Sullivan?
It's certainly not the Bilodeaus. They're the best of business people, and they're our neighbors up there. So this is nothing personal, but we bought this place 20 years ago when the Sagamore Inn was owned by the Paglanis. It was nice and quiet, and we're getting up in age now, but that's beside the point. They have a business plan, the Bilodeaus. In other words, they're proceeding with what they think is the best possible position for their business. We understand that. We've never objected to anything they've done since buying the inn. Number one, they built 2 decks, one on the side and one on the back. Never said a word about it. They had a tent out there. Never objected at all to that. And that being said, they recently purchased 1105 Sandwich Road, which is our house, right next to our house. When I was talking to Mike, who was, by the way, one of my students back in the 60s or 70s, when I was talking to Mike, he was saying that house is going to be used as like an overflow crowd if they had a wedding and or I believe it was a Airbnb. And so that being said, we still kept our mouth shut. And then with this current project, we think this is just one step too much. I mean, we go way, way back in the town, back in the 60s. We originally got this place because it was nice and quiet. We have a retirement. I'm retired. My wife is semi-retired. And we can picture now a situation where it's going to be, in other words, noisier than it was. People traveling from the inn to the other house that they purchased, they're not going to go quietly. So all this in our mind is making my wife and myself just come to this point where we said we wish this would not move forward. And
Okay.
that's about all I have to say right now. Let's just wait me one minute. Did I miss something, Joanne?
No, I think other than the fact that, the noise factor has grown increasingly from the property. And again, we're not complainers. We're not people that make a big deal out of things, but and so we haven't really come to complain about it. But there have been several occasions where we're trying to enjoy our backyard and the music is in our backyard. So I think it's just reached a point that we feel like there has to be a time when we say that's enough, that it's hitting our property value we would anticipate, and it's making it more and more difficult for us to live the life that we moved here for. So we just ask for your consideration of our concerns.
Thank you very much, folks. Appreciate that.
Can I
Is
weigh
there-
in, Mr. Sullivan's discussion?
I'm sorry, who's talking?
Suzanne Bilodeau, can I weigh in on their discussion?
Well, let me do this, Suzanne. There may be other questions from the public, so let's see if there's any other issues at hand. Is there anyone else from the public or who has dialed in that would like to weigh in on this project? All right, Suzanne, if you want to address that, you can address that.
Okay, on Monday of February the 15th, Bill Sullivan reached out to us and I had a great conversation with him. I asked him at that time, we had just recently built a outside side deck and it was very heavily used this year just because of the COVID situation. And I asked him at that time, did the outside side deck impact you at all during the season? And he said, absolutely not. We didn't hear one thing. As far as 1105 Sandwich Road, we bought that personally. It's not through the Sagamore Inn. It's only Michael and Suzanne Bilodeau. We do plan on using it as an Airbnb to support us buying that. So, Mr. Sullivan, as far as, I mean, I understand where they're coming from. We are actually looking at possibly buying their property. But as far as the noise level, we've always been very respectful. We always end things before the 10 o'clock hour. We want to have happy neighbors. We're not here to try to make our neighbors unhappy. And we always are going to work within the guidelines of the town to make sure that that happens.
Thank you, Ms. Bilodeau. Okay, I'm gonna throw it back to the board, and just for the education of the board members and anybody who might be at home watching this, the Sagamore Inn is what we refer to as a pre-existing legal non-conforming use. Okay, in other words, it was there well in advance of zoning, so it's protected. Sometimes you hear the term grandfathered being used, and that's a layman's term that most people understand. What we're here doing tonight, the legal test, the criteria, is whether or not these alterations and extensions of this existing legal non-conforming use, will they be substantially more detrimental to the neighborhood than is the existing non-conforming use? So at the end of the day, the board is going to be asked that question. Is this addition of these additional bathrooms and the addition of this area for the bar, is that substantially more detrimental to the neighborhood? So we've heard some testimony already on that fact. And now I'm going to ask members of the board if there are any comments, concerns. Let you speak. Mr. O'Connor? Unmute
Yes,
yourself.
Mr. Chairman, I've got a question for Mrs. Bilodeau concerning the operation of the bar. I get that it'll certainly serve functions, weddings, what have you, under the tent. It presumably will also serve when the deck is open. And so I just want to make sure that there's no, if there is music in the tent, there is no amplification at the bar. I'm concerned about noise. Any amplification, any music, how does this work in the business model?
That is correct. The entertainment would be within the tent. With that being said, we already are allowed to sell alcohol in the tent and have a bar in that tent. We're just trying to bring it to be more convenient for people as far as the bathrooms and to give more outside options. So this is nothing new that we already can do. And we can still, it just would make it's more convenient to have a permanent structure versus taking something, putting something up and taking something down on a nightly basis.
Understood.
Thank you, Mr. O'Connor. Mr. Clegg.
Thank you, Mr. Chairman. Question about the zoning. I assume that Sullivan's house is R40. Is that neighborhood all R40? And what is the specific zoning for the Sagamore Inn lot?
Our house is zoned residential, as is the house beside ours. I assume that's R40. And there aren't very many houses near where we are, so we only have those to go by.
And your lot is what size, please, Sullivan's?
2 1/3 acres.
And what is the
Backs up,
specific,
excuse
what is the zoning for the Sagamore Inn lot, please, Mr. Stroni? I don't know who best to answer that.
It's R40. The Sagamore's in an R40 district.
So that we have a non-conforming business sitting in a neighborhood zoned residential, 40,000 square feet per lot minimum. What actions have the Bilodeaus taken to shield the neighborhood from noise out in that tent?
We have installed shrubs along the whole property. to do that. And we're trying to get them to grow taller as we speak. But yeah, there's hedges along the whole perimeter, in the back, on the side of Mr. Sullivan's. So yes, we have done that. And we've also planted shrubs in the front of the tent and also to the side of the tent.
And what kind of vegetation did you plant between your lot and the Sullivans? What kind of trees?
Privet hedges. Privet
Say again,
hedges,
please.
privet hedge,
Privet hedge?
yes.
How tall is it?
Right now, they're about 4 or 5 feet.
I wonder if that is sufficient plantings. I
hoping-
wonder if a row of arborvitaes might have been more suitable.
Well, we have our varieties on the side of the tent area and also the side building. These privet hedges will grow quite tall. It's just, they haven't had the opportunity.
Takes time. Thank you.
Further from the board. Ms. Brown.
Yeah, I have a question about the weekends because Mrs. Sullivan, you made a comment about, trying to enjoy your backyard and there was a lot of noise. Was that on a night or was that on a weekend or what day was that?
So Sunday afternoons, I think often, and then also in the evenings, if there's a wedding or what have you at the inn, the noise travels down into our yard. And so it hasn't been from the deck, and Suzanne's right, that it didn't come from the deck. It came from when the tent is out there and it comes down into the yard and right into the bedrooms. We've had to close the windows in order to be able to sleep. And company has complained about it as well.
Mhm. Thank you.
Further from the board. Okay, I'm going to kick it. Oh, Mr. Gallo?
Yes, I'd just like to comment that the Sagamore Inn is iconic as the Sagamore Bridge. And the Bilodeaus have done an outstanding job.
Mhm.
And I'm glad that they bought it. They're great people to have in town.
Mhm.
That's all I got to say.
Thank
We
you,
agree.
Mr. Gallo.
We don't disagree with that. We don't disagree.
Ms.
Can I
Moore,
say
do you
one more
want,
thing? Excuse me.
well, hold on. Ms. Moore?
Yes, when they have a wedding and they have entertainment, do they need a license from the selectmen to do that?
We have that.
So do the selectmen put any restrictions on that entertainment and as far as timing? And has there been noise complaints lodged?
There has not. We are always done by 10 o'clock. And we make that a stringent rule to all of our outside parties. And that's within the guidelines of the town to be able to have entertainment till 10 o'clock.
Mhm.
That's as late as we've ever gone.
Mhm.
And that's as late as we'll ever go.
That's it. Thank you.
Okay, Ms. Brown?
Yeah, one other question is, we're talking quite a bit about the tent, but the tent's really not an issue, right? It's this new bathroom bar combination. What is the concern that the bar will contribute? Is there, why will the bar bathroom combination make things any worse or different than they are now? Is there some concern that there'll be more people, they'll be located in a different spot? What's the concern, I guess, other than the existing noise level is not exactly what you'd like, Sullivan's, but it's being controlled in a pretty responsible way. So what's going to happen when this new?
Okay, so I think that's a very valid point, and that's a great question because it's right on point. So I'll ask the Sullivans, specifically this extension, this alteration of the bathrooms in the bar area. How is that, just those two things, how is that going to make matters worse for you?
Well, thank you. That actually goes to my point. I was going to actually speak about the bathrooms more so than the bar. The bar is obviously, can be talked about separately, but the bathroom is a bigger concern to me or as much of a concern in terms of driving into our yard, in order to drive into our yard, we have to pass through the property of the, or pass by, I should say, the property, the Sagamore Inn. And I certainly think having outdoor bathrooms is a detriment to the value of our property, to the point that we've actually very seriously thought about moving. And we have talked to the Bilodeaus about the possibility of them purchasing our house. This is not something we're taking lightly. We're really, we feel this is very detrimental to the value of our home and want to probably sell it before it's impacted by this.
Thank you. Ms. Brown, you still have the floor if you.
Yeah, are there any plans about what the structure will look like?
Well, in the packet, they did submit architectural plans for everything, everything.
All right, I need to look. I'm sorry.
And these bathrooms are very in keeping with the property. The architect who drew them did a beautiful job. Right now, if people are in a tent, they have to walk up a set of stairs or go by our dumpster to get to the bathrooms. We bring in porta potties, people don't even use them. That, I think, is a worse thing to do than have a beautiful building that we're going to maintain and landscape and whatnot.
Thank you. Ms. Goldstein?
Well, I guess I was back in the music wafting over to the neighbor's backyard. Is there any way to mitigate that sound? Is there any way to, any kind of acoustic technology that could dim that or filter it?
They're licensed to have entertainment till 10 o'clock at night. If the music is too loud, somebody can complain and the police would investigate that. Again, the focus here tonight is not on the tent or weddings or anything of that nature. The focus is specifically on this bar area and the bathrooms. And will that alteration, that extension of the current use, will that be substantially more detrimental to the neighborhood? Not to just a neighbor, but to the neighborhood. So the Sullivans have made an eloquent case that they feel this impacts them. But we're not looking at just the Sullivans, we're looking at the entire neighborhood. So I just would urge you to focus on that and the question at hand.
You only have one person addressing the neighborhood, is that right? The Sullivans?
Well, I've asked for anybody else who's called in or who's on this Zoom meeting, and I don't see anybody else, and nobody's asked to be acknowledged or speak.
If I may.
Ms. Sullivan, one last thought, and then I think at this point, we're probably ready to put this to a vote, but go ahead.
Well, I'm sorry, did you want to say something? I just wanted to say, there really are no other neighbors. Our property is bordered on the conservation land on one side. And so there really are no other neighbors to speak up. So this is where we are. Did I cut you off?
No,
Okay.
no, I'm just saying, I'd like to concur that, once again, the Bilodeaus have been very accommodating, and we understand that part. But right now, like I say, we're thinking about selling our home, probably to the Bilodeaus or somebody else. And it's just not what we turned out. It's not why we bought this house. It's turned out to be something different. And quite honestly, it's making an impact in our lives. And that's about all I'm going to say. And I want to thank Sue for her presentation also.
Thank you, Mr. Sullivan. Okay, I have 2 sheets of people, so I just want to make sure the board is set, that there's no further comments or questions from the board. Okay, that being said, I'm going to kick it back to you, Mr. Doucette.
Yeah, Mr. Chairman, again, Louis Gallows lives in the neighborhood of Sagamore, so he also made comment on it. So we're not just talking about the abutters, but the neighborhood, and Louis is part of that neighborhood. And also with the construction of the bar and the bath, it would also be a sound buffer as well. It's 70 feet away from the property line on the side lot, and it's between the tent and the neighbors, the Sullivans. So it's also an additional buffer as well. And in these COVID times, we're trying to limit exposure, contact, and try to distance as much as we can. And to make people go back into the restaurant for the bathroom, which is the sole bathroom in the property, which is over 2 acres, it makes more chances for contact. And I know whether it's the COVID or whether it's the flu or anything, try to restrict those exposures is a good thing. And to service from the outside part to the outside residents or the outside patrons would be an improvement to that. So I think with all that put in, Mr. Chairman, I'm willing to make a motion for a supportive finding.
Okay, well, feel free to make your motion.
Okay, Mr. Chairman, I reviewed the supportive finding for the application of 10/2020 for the applicant for the Sagamore Inn owner Michael and Suzanne Bilodeau. The applicant proposes to extend the pre-existing non-conforming restaurant use by adding an outdoor bar and a restroom behind the existing restaurant. The property is located at 1131 Sandwich Road in Sagamore, shown on map 18.2 parcel 9 in a residential R40 district. The project is determined to be a lawful pre-existing use that exists prior to the adoption of zoning for the town of Bourne. The planning board is the permitting granting authority according to the section 2220 of the Bourne zoning bylaw. And based on the planning board's review of the exhibits, testimony of the applicant, expert witnesses, and the record of the proceedings, the planning board has found that the proposed extension will not be substantially more detrimental to the neighborhood than the existing non-conforming use, owing to the following. A, the inn was originally built circa 1900 and rebuilt after a fire in 1930. B, the inn was lawfully in existence before zoning was adopted in January 1950. C, the planning board is the permit granting authority according to section 2220 of the Bourne zoning bylaw. D, the Bourne zoning bylaw section 2320 provides for the continuance of the non-conforming use by maintaining the following: that the lawful use of any structure or land existing at the time of the enactment or subsequent amendment of this bylaw may be continued, although such structure or use does not conform with provisions of the bylaw, subject to the following condition and exemptions. I, that the requested extension or alteration will not be substantially more detrimental to the neighborhood than is the existing non-conforming use. II, the proposed project does not substantially change the existing use to the site or to the abutting properties and structures. The inn currently hosts outdoor events with a temporary tent, which will be used along with the bar and the bathrooms. The findings. Finding 1, the nonconformity is the location of the restaurant use in the residential district, which is not currently allowed. Conclusion, according to historic documents chronicled in the Bourne Historic Inventory and stated above, the Sagamore Inn was built in circa 1900 and rebuilt after a fire in 1930. Therefore, established before zoning was adopted in the town of Bourne in January of 1950. Finding 2, special permit granting authority. Conclusion that the Bourne Planning Board is a special permit granting authority according to section 2220 of the Bourne zoning bylaw, and a restaurant requires a special permit from the planning board. Finding 3, non-conforming structures or uses may be extended or altered, provided that the special permit granting authority makes a finding that the alteration or the extension will not be substantially more detrimental to the neighborhood than is the existing non-conforming. In accordance with the plans herein submitted, the site plan dated January 11, 1979 and stamped as received December 28, 2020, titled Plan of Division of Land of Anita Prada, Mrs. Pearson, and the architectural plans dated 10/14/20, 1 through 4 of 4 titled Sagamore Inn Proposed Outdoor Bar. In conclusion, the planning board has found that the expansion and alteration of the inn was lawfully in existence before zoning was adopted and may be expanded, although the use does not conform to the provisions of the Bourne zoning bylaw. Therefore, based on the aforementioned findings, I move to approve the supportive findings of 10/2020 with the following conditions. 1, this permit is subject to all the town of Bourne state and federal rules and regulations and bylaws. 2, adequacy of sewage system is deferred to the Board of Health. 3, that the adequacy of emergency access is deferred to the fire department. 4, all previous approvals of businesses unrelated to the operation of the restaurant shall be rescinded. 5, all permits and licenses required to serve alcohol outside shall be obtained from the appropriate authorities. And 6, the decision shall be recorded at the Barnstable County Registry of Deeds, Land Court Registry, and a copy returned to the Planning Department prior to the issuance of a building permit. That is my motion, Mr. Chairman.
Thank you, Mr. Doucette. Very comprehensive. Is there a second on the motion?
A second.
Second from Mr. Gallo. Thank you, Mr. Gallo. Discussion from the board on the motion. Is there any discussion on the motion? Mr. Clegg. Unmute yourself.
Thank you for the reminder. Mr. Chairman, I just take a little issue with Dan's statements, and I couldn't interrupt him when he went right to the motion, about doing this with motivation because of the COVID situation. Hopefully that, we're living in a temporary world here. And I appreciate Lou's comments about the neighborhood, and everybody in town respects the people that own that business. But I can't let go of concern for the people whose property abuts that. And I had to speak out because I do not think that any motivation to vote yes on this motion should come from the COVID situation. That's my only comment. Thank you.
Thank you, Mr. Clegg. Mr. Doucette?
Yeah, Mr. Chairman, my motivation isn't strictly driven by COVID, but also to address that the Bilodeaus have spent a lot of money and tried to keep their business afloat. And in doing that, they would also like to propose this bathroom and bar. Whether it is COVID, and like I mentioned, the flu or any other thing, any kind of distancing, whether it's now or in the future, people are more apt to do that. So it's not driven by COVID, it's not driven by the flu, but it's part of the understanding of why the Bilodeaus are here.
Thank you, Mr. Doucette. Appreciate that. Further from the board on the motion, Mr. Clegg, unmute yourself.
I guess it's probably too late for this comment, and maybe you'll want to cut me off, but why don't they enlarge the building and build indoor bathrooms? If they only have that one bathroom for the business as it is, and they're trying to expand their business, why don't they just expand the building?
We have done that.
Hold on, Ms. Bilodeau. We do have a motion on the floor, and it has nothing to do with why you will or haven't expanded and whatnot. So we're gonna have to keep to the motion. Okay, further from the board on specifically the motion that's on the table. Okay, I'm gonna ask board members to unmute themselves, and this is a roll call vote. Remember, the criteria, the legal test is whether or not this extension or alteration will be substantially more detrimental. A vote of yes means that the motion passes and that it is not substantially more detrimental. A vote of no opposes the motion and in essence says it is substantially more detrimental. So if you don't understand that, before you vote, please ask me to clarify one last time. Mrs. Zarovitz,
Yes.
Miss Brown,
Yes.
Miss Goldstein,
Yes.
Mr. O'Connor,
Yes.
Mr. Carroll,
Yes.
Mr. Gallo,
Yes.
Mr. Doucette,
Yes.
Mr. Clegg.
On Lou's recommendation, I say yes. Thank you.
Chair votes yes. Motion passes unanimously. Good luck, folks.
Thank you very much.
Thank you for hearing us.
Thank you. Item number 4, this is a public hearing for site plan review special permit number 11/2021 Otis Park Drive, Bourne, Rhino Linens of Cape Cod, redevelopment site with a new 4,800 square foot building in a water resource district zone 2. Is there somebody here on behalf of the applicant?
Good evening, Mr. Chairman. Zachary Basinski, professional engineer, Bracken Engineering.
Good evening, Mr. Bazinski. The floor is yours.
Thank you. I'm going to share my screen and have a little PowerPoint presentation for you. So again, for the record, Zach Basinski, professional engineer, here this evening on behalf of Stephen Mealy and Rhino Linings of Cape Cod. Mr. Mealy has also joined us this evening on the Zoom call. So again, for tonight, I'm going to start off, review Mr. Mealy's operations, step into the existing conditions of the project site, review some of the historic permitting on the project site, review the proposed site plans, architectural plans, and then touch upon the special permit criteria for the project site. So again, Mr. Mealy is here this evening to propose to demo and raise the existing building on the property at 1 Otis Park and construct a new retail production warehouse office building in its place. Permit approvals that we're seeking tonight are site plan review under sections 1230 and 2220 for retail greater than 1,600 square feet, and then special permits in accordance with sections 1331 and 4700 for the water resource district for lot coverages greater than 40% impervious and for natural vegetation removal greater than 70%. So Mr. Mealy's operation, he currently started this business back in 2004. He currently operates in the business park right now over at 5 Otis Park. Again, this is a retail service that applies bed liners and spray undercoating to vehicles, new and used vehicles. Mr. Mealy currently employs 4 full-time employees with this business. And now he's looking to expand his operation due to the recent demand in his products. So again, project site 1, Otis Park Drive, existing developed 40,000 square foot lot. It's abutted to the north by Marty's GMC, to the west by a commercial development, to the south by another commercial development. Otis Park sits to the north and MacArthur Boulevard to the east. Subject property sits within the B4 zoning district, as well as the water resource district in a zone 2. There's no FEMA flood zones on this property, and a small isolated wetland has actually been created on this property as a result of an old drainage system on the lot. This is a wetland system that's only regulated under the local bylaw in town. It's not state regulated. This parcel again was created in approximately 1980. So again, existing site property was created back in 1980. The existing building was the former Honeydew building on the property. That was granted approval back in 1981 and constructed between 81 and 82. After the Honeydew left the site, the project site sat dormant for a while. Back in 2014, Bruno's Burger was in front of the planning board at that time. They did receive a special permit and site plan approval. Unfortunately, that business did not survive on the site. For recent permitting, we have taken this proposal in front of the local conservation commission and were granted a order of conditions for this project. So again, as for the proposed project, we're looking to raise and demo the existing building on the property. We're looking to also improve the existing stormwater management system on the lot and protect the existing wetland system that sits right here in the front of the property and bring it into compliance with the Stormwater Management Act. After we bring those into conformance, there'll be some slight regrading of the site. And then we would be constructing the new 4,480 square foot building. You can see the proposed building is slightly larger than the existing one, but sits in the general same area of the lot. We would reestablish the existing parking lot that's here on site, reconfiguring the on-site parking so that we can have two-way traffic in this aisle. Under existing conditions, this was a one-way drive-through that came in and dumped back out onto Otis Park. So we're looking to keep all the clients and potential users of the site. They'd come in the front entrance, park here. So we've straightened out the existing parking spaces on the lot. And then we're looking to install these stormwater management areas to improve their site runoff on the property. Our project would also upgrade the existing on-site septic system on the lot and bring it into compliance with the current Title V regulations. As part of the proposal, we do abut 2 streets. So we are planning to plant 6 trees along Otis Park Drive and 64 shrubs in accordance with the zoning bylaw. Final determinations on what those plants would be can be discussed this evening. As usual, we would like to request that a final planting plan be submitted as a condition at the end of the project if approved tonight, and that be reviewed and approved by staff. We have also submitted a waiver request for the existing trees or for proposed trees along the MacArthur Boulevard section of the property. And this is due to the existing wetland vegetation on the lot. Lastly, for the proposed plan, site lighting, on-site parking, loading spaces, dumpster areas have all been designed in accordance with the plan sets. And you have all that information in the application packages that was submitted to you. So as for the proposed project, we believe this is going to be a vast improvement for the area and for this lot. The changes in the stormwater management will protect the isolated wetland that sits on the property, which will also protect the groundwater resource district. Currently, all impervious areas drain to the wetland system and are recharged on site, so no stormwater goes off. All that would be kept on site. The proposed building would be serviced by a tight tank. So if there are any potential leaks or vehicles inside the building, it's all maintained. Again, that would protect the groundwater resource district and the associated wetland system. The overall project has a slight reduction, approximately 0.5% of impervious area on the lot. We also have just a slight increase in natural coverage on the lot. We are currently over the 70% natural tree cover at 80.5%. We are looking to go up to 82.2%. Again, this is just to install the stormwater forebays on the southerly portion of the property, and then just to readjust the site grade around the dumpster on the property. Again, we feel that this is acceptable because we'd be protecting the groundwater resource area as a result of this. And again, this does comply with the on-site or the zoning bylaw where all stormwater is treated and recharged back on site in accordance with the special permit criteria of the bylaw. One of the biggest improvements for the area, the current project has a vast reduction in the nitrogen loading on the property. Under the restaurant use of the property, this site, if reestablished as a restaurant, would have a 21.3 parts per million. As we all know, in the groundwater resource district, we try to have properties reduce that down to 10 parts per million. So this project would actually get below that down to 8.8 parts per million. And the project has, Mr. Mealy has spoken with Mr. Profit in the Pocasset Water Department and has received a approval or a letter of support for the project from the Water Department. Architectural plans were submitted as part of your packages. As you can see here in the renderings, the lower image is what would be seen from MacArthur's Boulevard, and the top image would be what you would see from Otis Park Drive looking south. Again, very Cape Cod style. It is a metal building. We do have some nice protrusions on the side of the building to break up the steel part. There would be a metal roof. We believe the building would be very in harmony with the abutting properties in the area. Floor plans were also submitted as part of the package. Again, Mr. Mealy is trying to expand his business and the operations, so this building extends the inside storage areas for the number of vehicles he can work on at a time. So we have 2 bays here that work on the undercoating portion. There's another prep bay inside the building, and then there is a building here for the rhino lining. Comes in, cars are prepped here, and there's an internal spray room for all that. So all the chemicals and everything are maintained inside that building. There's also a independent area for the storage of any chemicals associated with his business. And again, his chemicals are they're not petroleum based, and they all have MSDs cards that are acceptable for the area. And again, his business has been operating since 2004 up at 5 Otis Park and has not had any violations or any contamination. So as for the proposed project and the special permit criteria, we believe that the safety and traffic flow of the site is protected with the reconfigurations of the traffic flow, as mentioned earlier. We believe that there's already adequate utilities in the area to service the proposal. We believe that will be a vast improvement to the natural environment, again, bringing the stormwater system into compliance and protecting the wetland system, and then also protecting the groundwater protection area as mentioned. Again, we believe that the use is in harmony with the surrounding businesses, both visually and by use. And project has no proposed housing, so we'll have no effect on housing in the town. And again, we believe it'll protect the groundwater district. So with that, Mr. Chairman, I will turn it back over for questions and comments.
Okay, any questions and comments from board members relative to the project? I'm going to start with Ms. Goldstein and then Mr. O'Connor.
Just a question. What does brining the site mean? Brining the site?
Oh, we're just grinding or just the asphalt that's on the site, removing the existing asphalt.
That's what brining the site means?
Yep. It's going to be taking the existing asphalt out when we redevelop the site and then putting new asphalt back.
Thank you.
Mr. O'Connor?
Zach, on your site prep plan, you appear to be saving the business sign on the highway edge. What's your client's plan for signage?
We would be back in front of the board if approved with a plan. If the plan is in accordance with the signage bylaw, we go to the building department. If we required any plans through their approvals through the board, we'd be back in front of the board.
Well, let me ask you this. You're preserving that existing sign. Do you expect a sign at that location?
Correct, yes.
Okay. Mr. Chairman, I have another question too. Having to do with the demolition of the pavement. Is the new pavement edge at the front of the site going to be in the same location as the existing pavement edge?
Yes, if I share my plan, I can show you. Or share my site here. So the front edge of this pavement stays the exact same. We're just squaring off these corners right in here, just to make the parking so that they're perpendicular. Because right now, under the existing conditions, you can see that they're angled, but the front limit of this pavement stays the same as what's there today.
Okay. It has to do with the existing planting in that area and the overall planting. Jen Copeland, Assistant Town Planner, said that we should waive the street trees along MacArthur Boulevard. I agree with that. You don't want someone coming off the highway and hitting a tree that's 6 inches in diameter. I think Mass Highway has rules on that too. I would like to save those plants, the 55 that is earmarked for the MacArthur Boulevard side. Currently, there is a sort of a discontinuous line of shrubs at the front of that parking lot that at least partially screens at least the bulk of cars parked in that location. If your pavement is going to, the proposed pavement is going to coincide with the line of the existing pavement, is it possible to put a line of shrubs behind your timber rail wall to at least hide the underside of those parked vehicles from MacArthur Boulevard?
Yes, we could
And
probably.
wood drops off, it starts to drop off. I'd like to think we can fit in a line of shrubs, an evergreen. Even if someone took a chainsaw to those existing shrubs, put in the timber rail fence and let them grow back. They will grow back, and plant similar species, filling in the gaps in between. I'd like to see some kind of evergreen screening between the front of those cars and MacArthur Boulevard. And it doesn't have to get very high. You can cover the bulk of the car with something 42 inches high, just to get to the top of the hood.
Yeah, we could look at plantings on that. We would have to talk with the Conservation Commission. Again, we are in a wetland resource area right there.
Right.
So it may have to be more of a natural plant because of that.
I get it, but just some kind of screening. And also at the corner closest to Otis Park Drive, near where your embayment is, that corner of the parking lot could use a little bit of screening.
We could put something in this general area right in here.
Exactly right. And I applaud your idea of submitting a completed planting plan to the planning department, because we need more of those in these types of proposals. Right now, It's sort of a sketch. That is, there's no species, there's no size, there's no spacing. So if indeed this project does have a performance grant, in absence of a true planting plan, we have nothing to hold that performance. We have nothing to judge the performance bond against because it's just too vague. It's a pavement plan without a specification.
We can provide that specification.
If you do that. Thank you. That's all.
Thank you, sir.
Thank you, Mr. O'Connor. Zach, I need you to take that. Okay, thank you.
Already beat you.
Mr. Clegg, unmute yourself, please.
Thank you, Mr. Chairman. Two questions. Actually, the first thing is a suggestion. When you come back in with that full planting plan, landscaping plan, maybe we ought to have Mr. O'Connor as our board designee to work with the planning department on the review and approval on that. Would you object to that, Zach?
Nope, we'd gladly work with Mr. O'Connor.
And I don't know who's doing the motion on this, but I would ask that that be factored into the conditions. My second question has to do with the existing catch basin between the property and MacArthur Boulevard. Is that area catching runoff from Otis Park Drive, or is it only catching runoff currently from your property?
It catches runoff from Otis Park Drive and then just a section of the property up in the front here because of the site grading.
So are you going to be doing any regrading where your property contacts Otis Park Drive that would in any way prevent the Otis Park Drive runoff from reaching that?
Currently under the current site conditions, the Otis Park Drive continues on. Our site grades down onto Otis Park on this entrance drive.
So your level is above the Otis Park Drive level?
Yes.
Thank you. That's all I have, Mr. Chairman. Thank you.
Thank you, Mr. Clegg. Further from the board, Mr. Gallo, unmute yourself, please.
Yes, Mr. Chairman, I might have to recuse myself from a vote on this because I had given a price on the raise of the building to a contractor, not knowing about the going to planning board. But I don't know if I can still make comments on the site. I'd be happy to do that.
Actually, Mr. Gallo, if you're going to recuse yourself, probably the most prudent thing to do would be to not comment on the project.
Okay. Fine.
Further from the board, Mr. Clegg.
Back again. Some of the board members will recall when we reviewed this plan for Bruno's Burgers, there were parking issues. How many total parking spaces are you providing, Zach?
We have 13 and the parking demand is 12, so we're one space over.
You're one over. Thank you very much.
Ms. Brown?
Yeah, just a quick question. It is in a water resource district. It is a chemical process. And it sounds like it's well contained and well handled. And Zach did mention that. Are there any concerns? Does anybody have? I'm not sure there were but I just wanted to mention it. I mean, it is a slight concern of mine.
Really?
Well, Zach, do you want to speak to that? Because I think you touched upon that earlier.
Yeah.
Right. So again, I mean, the site's been designed, trucks would come in, they would unload right here. There's a door on the floor plane in the back. So it's very limited area outside when these chemicals are outside, and it was designed this way. And it goes into that internal storage in the back of the building here. Just realized I wasn't sharing my screen.
Okay.
So again, parking comes in the back. We have a door that goes in and then that gets into the storage area. So very limited contact outside with chemicals. Everything comes in sealed 55-gallon drums. Everything's inside the building. Once it's in the building, all the product, there's very little waste on this. Speaking with Mr. Mealy about this, he generates about 5 gallons of waste that are stored inside the building. And that 5 gallons is generated typically over a 3-year period. Everything
I know.
that's sprayed goes on the car and it leaves that site. If there was ever a spill with the MSD sheets, all this stuff is recommended to be picked up with Speedy Dry. So again, it's all inside the building. If there was ever spilled and it got out, it would be contained inside a tight tank outside the property here. He already has a service company that he works with that takes anything away. The site again has also been redeveloped because of these stormwater management areas. That these are another way to contain any potential spill before it goes into the groundwater, because these would be lined forebays to prevent any infiltration into the ground. So again, it would have to come out of the building, across an impervious parking lot, then into a lined area which we could soak everything up. So very, very, very low chance of any spills getting into the ground.
That's very helpful. Thank you.
And again, he's been operating, since 2004 and has not had any spills yet.
Mhm.
Further from the board. Okay, is there anybody in the public who has dialed in or is here on the Zoom call? And I'm getting some feedback from somebody. Please mute yourself if you're not speaking. But is there anybody in the public that wishes to be recognized and speak on this matter? Okay, Mrs. Arvitz, you were the reviewer on this project. Your thoughts?
Yeah, I was the reviewer on this project. I was actually pretty excited to see the address since this building has been empty for so long. And thanks for the back story, Zach. I'd forgotten all about when Honeydew Donuts opened and when Baker Boy closed and everything else that's happened there. In my opinion, this whole building coming down is a benefit to the neighborhood. Rhino Linings of Cape Cod has operated an Otis Park Drive without complaints to the building department and has a good reputation. It offers a unique service to trucks, and we have a lot of those in this area. The new structure, while having a larger footprint, is attractive and not excessive for the nature of the business. It fits in with the surroundings. Even with the increase in business due to location, I don't think the additional customers will be a detriment to the neighborhood, nor will traffic become a hazard. The circulation and pedestrian flow on the site has been well planned, and considering the constraints of the lot, there's adequate parking available with accessible spot, handicap spot with the ramp. The requirement was for 12 spots. They'll have 13 in total. Cars will not be leaving the parking lot and going directly on the highway. There's a safe entry and exit now from Otis Park Drive. And while the existing impervious surface is being reduced, it will still be greater than 40 max. But I still feel this is an improvement to the existing conditions, reasonable considering the constraints of the lot. The lighting is shown to illuminate the edges of the parking lot, should not add to the light pollution along the highway or be a distraction. The septic system is going to be upgraded and will be approved by the Board of Health. The fire department has reviewed. I did not hear whether or not the fire department has reviewed the emergency access, but they will determine if that's adequate. The site is located in a water resource district. The Conservation Commission did approve this with several conditions. There'll be inspections ongoing allowed for oversight during construction. The installation of sediment control starts 5 days prior to construction. The site's subject to Massachusetts stormwater standards and best management practices, and they'll remain in place till it's stabilized. Conservation can also count on the contractor to add more erosion control for unforeseen circumstances. And post-construction, there are conditions regarding the maintenance of log for operation and management of the stormwater systems that will be kept for 3 years. This is in accordance with the long-term pollution prevention plan section of the approved stormwater report. Disturbed areas covered with vegetation will be inspected to make sure they have been established and are suitable to withstand erosion. I've summarized basically what are the key points of the order of conditions forwarded to me by Sam Haynes, our conservation agent, and they're very thorough, and there's going to be a lot of oversight with regard to conservation and runoff and stormwater management for this project. I'm satisfied that that's going to be adequate. And lastly, the proposed landscape plan that we have discussed. The details, I would like to see some of the details as the plan is developed that we've discussed tonight. And I have drafted a condition that can be added to the list of conditions that I have for the project. And basically, I'm happy with the plans and I'm thrilled that something is going in. I'm glad there's a business that's doing well and has no issues and it's gonna stay in Bourne. So that's my opinion.
Okay, well, the floor is still yours if you want to roll into your motion.
Okay. Mr. Chairman, I have reviewed the site plan review special permit application 11-2020, and the applicant Rhino Linings of Cape Cod proposes the redevelopment of property at 1 Otis Park Drive, located shown on map 35, parcel 44, in a business 4 B4 district. The applicant proposes to raise the existing building and construct a new 6,244 square foot commercial building at 1 Otis Park Road for vehicle lining application services. Project is determined to be an allowed use within the B4 zoning district under section 2220 land use classification under retail sales with greater than 1,600 square foot of floor area and storage. Based on the planning board's review of the exhibits, testimony of the applicant, experts, witnesses, and recording of proceedings, the planning board has found that the project is consistent with the town of Bourne zoning bylaw, section 1230, site plan special permit, section 1331, special permit criteria, and section 4700, water resource district. And it will not have an adverse effect which overbalance its beneficial effects for the neighborhood or the town. Further, special permit 11-2020 meets the criteria for a special permit of the following. A, pedestrian vehicular flow and safety allows for safe traffic flow. B, the utilities will be connected with minimal disruption the surrounding area. C, impacted areas to the natural environment will be revegetated. D, impact upon nearby developed premises is minimized. E, the proposed building is visually compatible with the surroundings. F, the total impervious surface of 43.7% and removal of ground cover vegetation to 82.8% will not have a detrimental impact on the water resource district. G, there is no impact upon the town's needs for year-round housing. Therefore, I move to approve the site plan special permit 11-2020 in accordance with the following conditions. 1, grant a waiver for the required plantings, 6 trees and 55 shrubs along MacArthur Boulevard in order to preserve the integrity of the existing wetland. 2, this permit is subject to all town of Bourne state and federal rules, regulations, and bylaws. 3, the prohibitions of the water resource district under section 4700 must be included in all leases and posted in an area visible to the public. 4, prior to the issuance of an occupancy permit, an as-built plan must be submitted to the planning board showing all appurtenances above and below ground. 5, adequacy of the sewage system is deferred to the health department. 6, adequacy of emergency access is deferred to the fire department. All tier 1 documents as outlined in the building code shall be provided to the Bourne Fire Department. 7, this decision shall be recorded at the Barnstable County Registry of Deeds, Land Court Registry, and a copy returned to the planning department prior to the issuance of a building permit. And then the next 2 I drafted. So if there's anyone that would like to help me with the wording, please feel free to jump in. 8, submit a detailed landscape plan prior to the issuance of occupancy that shows the planting installed according to the general regulations set forth in section 3500, landscaping and streeting in the zoning bylaws. This should be done in a timely manner so the proper review can be conducted before any scheduled meeting with the planning board for approval. And 9, prior to the issuance of a building permit, building plans and elevations, all stamped by a professional, must be submitted. I only added that last one because the elevations that we received didn't have an address or a stamp on it.
Thank you, Mrs. Arvitz. Very comprehensive, very complete, very impressive.
Thank
Is
you.
there a second on the motion?
Second.
Mr. Clegg on the second.
Mr. Chairman,
Yep.
I just had one comment before we go to the seconding on the conditions. I think Mrs. Saravitz said on like number 3 that we were waiving the 6 trees and 55 shrubs on MacArthur Boulevard. I'm good with waiving the trees on MacArthur Boulevard. I'd like to repurpose and relocate the 55 shrubs. That's where the shrub budget, so to speak, would come from to screen the parking lot.
Okay, Mr. Bazinski, is that a practical, is that possible? Is that practical?
Yeah, I don't think we're gonna get full 55 plants on that, but I mean, we will definitely put the screening in like Mr. O'Connor requested before underneath
Sure, that-
and do
I
that.
intended that just to be a budget.
Yep.
That is, if it takes 40, 35, that's fine.
We
Thank you,
can definitely work with that.
Okay, so Mr. Clegg did second the motion. So discussion on the motion. Anybody from the board? Okay, I'm going to ask you to unmute yourself. We're going to do a roll call vote. This is for a special permit. This is a supermajority vote. Mrs. Zarovitz,
Yes.
Miss Brown,
Yes.
Miss Goldstein,
Yes.
Mr. O'Connor,
Yes.
Mr. Carroll,
Yes.
Mr. Doucette,
Yes.
Mr. Clegg,
Yes.
Mr. Meyer, are you still participating?
Yes.
And your vote is?
Yes.
Thank you. And the chair votes yes. Motion passes unanimously.
Thank you very much.
Thanks. Good luck.
Thank you.
Yeah, good luck.
Thank you, Mr. Meyer, for pinch hitting. Okay. Next agenda item,
Mr. Chairman, excuse me, who is Mr. Meyer substituting for?
Mr. Gallo said he had a conflict.
Oh, I'm sorry. That's true. You got it. Thank you.
Agenda item number 5, this is an 81P, 72 Lewis Point Road, 1 lot subdivision into 2. Is there anyone here on behalf of the applicant?
Good evening, Brad Bertolo with JC Engineering.
Good evening, Brad. Floor is yours.
Thank you. Again, Brad Bertolo with JC Engineering on behalf of the property owner, James Deedy. This project, or the plan before you tonight is to request approval or request an endorsement on an approval not required plan of land to adjust the property line on a pre-existing lot. Mr. Deedy owns the abutting lot at number 72 Lewis Point Road. He's been living there since 1988 and has done vast improvements and enjoyed the use of his property. We have, based on a survey from about 2014, determined that some of his improvements encroached onto the abutting property. Fast forward a few years, Mr. Deedy had the opportunity to purchase this property at 9 Nye Lane. So he currently owns both properties. This subdivision, this portion of the subdivision was created in the 1950s. And the lot that we're working on today at 9 Nye Lane, as well as the lot at 72 Lewis Point Road, were originally one lot. But in 1986, the zoning bylaws at the time, or this area was zoned in the R20 zoning district, which required a minimum of 20,000 square foot lots. 2 lots were created in 86, and then a house on each lot was built in 1987. So Mr. Deedy purchased this property at 72 soon after the house was built. This project involves the creation of an unbuildable lot. It's Land Court Lot 68. It's approximately 1,800 square feet, has about 14 linear feet of frontage on the roadway, and extends the full depth of the property. The intent of this plan is to create this lot, which is, we typically call parcels, which in most situations are considered unbuildable. But in this case here, we're following land court procedures and we're calling it a land court lot 68, according to their requirements. And we have a note on plan stating that said land court lot 68 is unbuildable and is to be conveyed and combined with the abutting lot. Again, we have two pre-existing non-conforming lots today. The current zoning is R40, which requires 40,000 square feet. Both these lots were developed back when the zoning was R20. The lot that is diminished in size, lot 67, has adequate frontage, and that's the main criteria that planning boards look at when reviewing lots or plans to determine if they can be endorsed under approval not required. So we are taking a lot that is pre-existing non-conforming and would make that more non-conforming. But at the same time, we're making the abutting lot more conforming. As you can see, the land court lot 67, the new lot area would be over 21,700 square feet, which just happens to be above the minimum lot area requirements when this lot was created. I know that it's not a factor to look at when reviewing this because it's the zoning is now R40, but it's just a nice fact to understand that we're not creating a lot or minimizing a lot lower than what was originally allowed when this lot was created. At the same time that we're increasing or decreasing the nonconformity on one lot, we're also providing more setback between Mr. Didi's pool house and correcting some encroachments on his property, which includes some of the pool area and fence and some landscaping that not shown on this plan. At the same time, or even though we're lowering the amount of lot area on this lot by adjusting the property line, we're not creating any more non-conformities. We have a pre-existing non-conforming lot, still non-conforming. We're not creating a new buildable lot. We have between the two properties that are buildable, there's still two houses. There's not going to be any more than two houses or two lots. The house meets the zoning setbacks from the new property line. We're increasing a zoning setback to the existing pool, which currently side setback requirements in this zone are 15 feet under the current bylaw. The septic system still meets, excuse me, the septic system still meets the setback requirements for a property line. We also went one step further and took a look at the zoning bylaw in regards to non-conforming lots and the total gross floor area and total lot coverage that's allowed on these lots. This lot under the R40 zoning district is allowed to have 20% lot area lot coverage. It also applies to non-conforming lots that are over 15,000 square feet, can't have more than 20% lot coverage. 20% is approximately a little over 4,000 square feet. The current house and deck, steps and porches are about 2,000 square feet. So again, we're adjusting the lot line, but the proposed buildable lot, which is currently developed already, maintains the minimum frontage that's required, which according to the A&R handbook that we utilize, as well as the town planner utilized for their review, which we received a copy of it yesterday, basically states that there's case law out there that says that this plan would classify to be endorsed under an approval not required, specifically because the lot has the adequate frontage. And we've put statements on the plan that states that the unbuildable lot is unbuildable, or the smaller lot's unbuildable. And we also have a statement on the plan that that's under your endorsement, that no determination as to compliance with zoning requirements has been made or intended by this endorsement. So if the board has any questions on the proposal, I'd be happy to answer.
Thank you, Mr. Bertolo. Okay, what I'd like to do is explain a little bit about what's going on here. We've had plenty of A&R. For the sake of those maybe at home, A&R, which you'll hear referred to quite often, means approval not required. In this case, you filed an application for endorsement of a plan not to require approval. So the test, the legal criteria in Mass General Laws, Chapter 41, 81L is as follows. Is the lot on a public way? Do the lots, the subdivided lots, do they meet the minimum frontage requirements? Does each lot have frontage on the plan, and does that frontage provide adequate access, vital access, as sometimes is said? And I think in this case, that criteria is certainly met. These are existing roads. Nobody will deny that. And the frontage is there, and access is adequate. The interesting thing about this particular request is, as you've said, you're going to create a you're going to make a non-conforming lot, what is now a legal non-conforming lot, more non-conforming. And that potentially creates issues for you. But as or your applicant or the applicant, but as you've pointed out, that's not the issue. The issue is, do you meet the law and the requirements to get the planning board to endorse the plan as approval under the subdivision control laws not required? And I think there's no question about that. However, because this is a unique circumstance, when we get to the point where we make our motion, I'm going to suggest to the board that we put in some caveats as to the unique nature of what will ultimately be the division of this plan, and what that means for, as the court has said, and I haven't created this language, I've just taken it from the court cases. As the courts have said, this is sort of a buyer beware, a caveat, so that down the road, if somebody is, if he wants to sell off one or both lots, that people are aware that this had gone through the A&R process, but that the board did not make any conclusions as they relate to conformity with zoning bylaws, in any case. So that being said, that's the background here on this A&R. And I just thought it was important to bring this to the board so that you have this information. And it's kind of a unique situation. It's not unheard of, obviously. The case law that's the seminal case on this is the town of Harwich. So it's right in our backyard, so to speak. So in any case, are there any board members that have any questions relative to this A&R? And if not, I'm going to make a suggested motion, and that may get taken up. Mr. Clegg.
Mr. Chairman, I know you're law school trained, but I find it a little bit unusual that you're kind of coaching the board towards a decision. I'd like to hear, I would, by my experience, we would normally hear that kind of coaching from the town planner, and I'd like to hear her dissertation on the same thing, please.
Okay, well, before we get to that, is there anyone else on the board who has any questions or comments? Ms. Brown?
Yeah, I just wanted to say that I had been wondering about when this property was sold, the conveyance, how that information would be shared. And so you addressed that, and I appreciate that. But I also would mind hearing from Corinne.
Sure. Ms. Goldstein?
Yes, I'm not quite clear on the status of this newly created, more non-conforming lot and what its status is, especially the part at the end when you described that it wasn't something subject to zoning bylaws. In other words, could that non-conforming lot, the one that's being created, that's more non-conforming than before, ever be developed? Are there any circumstances under which it could?
Well, if they go forward with this plan, they lose the protections they have in place right now. They're a legal non-conforming lot. When they make it more non-conforming, they lose those protections.
They lose it, okay.
And the court made that clear. But the court did say there are valid reasons why somebody would do that. So as far as motives, I don't know ultimately what the motives are here. I think Mr. Bertolo was quite clear. It's trying to clean this up, and they have some encroachments and they want to fix the setbacks. And they may end up going for a variance to, if they go to the zoning board of appeals and say, we had to move a lot line to fix encroachments, the zoning board of appeals may give them a variance and they may be back in compliance. But there's a lot of moving parts here. It's an interesting, it's an interesting exercise here under the law, because it's sort of, in my opinion, it's sort of counterintuitive that you would take a lot that's legal non-conforming and make it and lose that legal protection.
Right, that's fine.
Yeah, so the fact that struck you as odd is appropriate. All right, further from the board. Ms. Moore, do you want to weigh in?
Yeah, I would concur with how Steve presented that. I did forward, hopefully everybody got it, my memo and the supporting documentation went along with that memo. Unfortunately, A&R plans do not allow the planning board to deny a plan because it doesn't meet zoning. The test is, does it have the frontage? Does it have adequate access? And that basically leaves it at that. What it does is puts the burden on the staff of the building inspector and the planner that when a plan is filed to determine if that lot is a legal non-conforming lot. If we consider it not legal, then we would have to forward that to the zoning board of appeals. They would either have to get a special permit to extend a nonconformity, but if it's not a legal nonconformity, they would need to get a variance, and then they would have to prove what the hardship is to get that variance. And if the zoning board of appeals determines it was a self-imposed variance, they may not get that. So that is why we are suggesting through Steve's comment is that we make sure we put on there that the board has made no determination that this meets zoning. So if you were to purchase this lot, you would have a heads up to say, this lot may have a house on it and I can live in that house, but if I wanted to extend that house, add on to that house or make improvements to that house, I need special permission from the zoning board of appeals to do that. And they do not have to grant that to you. If it was a legal a non-conforming lot, under the law, you have a right to extend that. You can't make it more non-conforming, but you can extend it if you already have that non-conformity. So they're going to lose some of those protections on this lot.
Mr. Clegg.
Thank you, Mr. Chairman. I thought I followed this all the way through, and I agree with you on the points that the planning board can rule on an A&R. And when I look through all of that, I say it's a no-brainer. If he's willing to give up buildability on a non-conforming lot by taking part of it and giving it to the adjoining lot, that's his decision. We put it in our board decision, and it prevents anybody from doing anything with the non-conforming lot from here on out. But Ms. Moore, after I go through all of that and reach that conclusion, then I read this infection invalidity information statute that you sent us, and I don't understand why that doesn't apply here, and should we take that into consideration?
It does apply, but the biggest difference here, if it was a vacant lot, they would lose their right to get a building permit. So that could not even be challenged. but this has a house on it. So there's already a house, so what they're jeopardizing is to improve this house and to increase, because it's considered a non-conforming lot. The house may meet all the setbacks, but because the lot does not have any protection, they can be denied to approve to put an addition on it, a deck on it, or anything to improve that. So it's one of those things that if you don't have a building inspector or someone that reviews the plans that look deep into this, you would miss it. Because you would assume that it was a lawful pre-non-existing. So if you put the notes on the A&R, once we bring the A&R up, it gives us a red flag to say, hey, there's an issue here, and we look further into it.
Have you had a case in your tenure here with the town planning board where infectious invalidity was invoked?
There have been a few of them, yes.
There have been.
Yes.
So what I understand you to say is there's a house on the lot, and if he goes to try to make an addition to that house, he'll be prevented from any further?
He could be, yes, because what happens is he's increasing the nonconformity on a small lot. Now, like I said, if it was protected, a lawful, we're using that word a lot tonight, a lawful non-conforming lot, then he has all the protection in the world, because what case law says is a single family home is one of the biggest investment that a person will make. And so the courts look at that and say they should be able to make improvements to their property. But if you knowingly buy a property that has invalidated its protection, then you have to knowingly know that you did that. That's why we put this on the plan. So that doesn't usually hold water when you go to the Zoning Board of Appeals asking for a variance.
Okay, I'm very satisfied with your explanation, and I thank you for that. I just have, Mr. Chairman, after you take the vote, I have one procedural question about this that I'd like to ask you, but I don't want to get in the way of the vote. Let's move it along.
Okay, so I would suggest that the motion to be made here would be as follows. Motion to endorse the plan as approval under the subdivision control law is not required, with the following 3 items. Number 1, the above endorsement is not a determination of conformance with zoning regulations. 2, no determination of compliance with zoning requirements has been made or intended. 3, planning board endorsement under the subdivision control law should not be construed as either an endorsement or an approval of zoning lot area requirements. Is there anybody who'd like to make that in the form of a motion?
So moved.
Moved by Ms. Brown. Is there a second?
Second.
Second by Mr. Clegg. Is there any discussion on that motion? Okay, this is a roll call vote. Mrs. Arovitz,
Yes.
Ms. Brown,
Yes.
Ms. Goldstein,
Yes.
Mr. O'Connor,
Yes.
Ms. Carroll,
Yes.
Mr. Gallo, Mr. Doucette,
Yes.
Mr. Clegg.
Yes.
Chair votes yes. Mr. Gallo, last call.
Should Mr. Meyer vote?
No, this isn't a special permit and there's no
Okay.
conflict for Mr. Gallo.
Gotcha.
So, just record, Ian, we're gonna have to record Mr. Gallo's vote as, just present. Okay, Ms. Clegg, you had a question?
Yes, I did, Mr. Chairman. This is a very interesting A&R case. When I got it, it made me realize we haven't had an A&R come before this board for 6 months. And you made the statement that in the course of this discussion, that you felt this one deserved board consideration. What's happened to the other A&Rs in the last 6 months?
Typically they're handled now through the planning department. If the planning department makes the determination that the A&R requirements are met, then they would approve that administratively.
And you feel that that meets the requirements of Chapter 41, paragraph 81P?
Under the law, there is no requirement for a public hearing on an A and R.
That's correct, but there is a requirement for a board vote, Mr. Chairman.
That's
You
what we
are
just
delegated, you are delegated by this board, and this is in line with 81P. You are delegated authority to sign the approval instead of a quorum of the board signing that approval. So you have that delegation, but you do not have the delegation to approve an A&R. And that is specifically called out in 81P, that it requires a board vote. And I take issue with any and all of the A&Rs that you may have approved over the next 6 months. And I don't know how many there are, but I do know from personal contact of one at least, where when I asked a friend of mine who said he was submitting one, whatever happened about it, because it never came before the board, he said, oh, I got approval back around the 1st of November. I think that your behavior is way out of line, Mr. Chairman, and I would urge.
I can tell you this, Mr. Clegg.
All right, wait a minute, please. Do not cut me off. I would request that you schedule an executive session for this board to discuss your behavior on this matter. And if I have to, I'm prepared again to go to the courts if that's what it takes to challenge you on your behavior. Would you agree to that, please?
I will take it under advisement. Thank you, Mr. Clegg.
You're not going to answer any more than that?
I'm sorry?
You're not going to answer any more than that? Why?
I just said I would take it under advisement.
I would like an attorney's, a practicing attorney's, not an attorney whose license to practice has been suspended.
Okay.
To give me a judgment on that.
Thank you, Mr. Clegg.
I would like to this referred to the town council for a ruling, Mr. Stroney.
Okay, well, I can tell you this, Mr. Clegg, the A&Rs will be coming back to the board. So if that's not satisfactory, I'm sorry, if that's not satisfactory.
I think you owe it to this board.
Not
to have a meeting
satisfactory
with the
to you.
board in private with the town attorney there to discuss the impact. You're putting the members of the board at personal risk by your behavior, and you've been doing it for 6 months. And it's illegal, it's unlawful, and you need to be called on it. I would like a meeting in executive session with the town attorney to address that, Mr. Stroney. Would you schedule such a meeting, or do I have to take it to the attorney?
Thank you. Item number 6 is a discussion of the procedures involved in zoning bylaw changes by the planning board. Folks, it's dawned on me that the process for bringing zoning bylaw changes or amendments to the town meeting is a process that is maybe not understood by everyone, particularly the public. So what I wanted to do this evening is just sort of go through the procedures involved in the planning board and their role in any sort of zoning changes or amendments, okay? So essentially it's this: any town member, a voter, can bring a zoning bylaw change directly to town meeting. If it's a town meeting, an annual town meeting, they can bring it with 10 signatures. If it's a special town meeting, they need 100 signatures. Now, they can always bring it to the planning board and request that the planning board sponsor that change. If in fact the planning board decides that it's a good bylaw change, a zoning bylaw change, the planning board can decide to sponsor that change. What we need to do at that point is then the the planning department, the planning board gets behind the amendment, the change. And we're required to have a public hearing prior to the town meeting. So we're sort of under the gun here because we missed our meeting 2 weeks ago. And we're gonna have to get that public hearing in the middle of March, no matter what happens tonight, because we do have a flood zone bylaw that needs to get on our books at some point, or the town runs afoul of some environmental regulations and we're at risk of being fined. So in any case, what's happening tonight is proponents of various bylaw changes have asked us to put them on the agenda. I'm going to give them an opportunity to explain the rationale, the reason behind these changes. And then at that point, the planning board can take a vote as to whether or not we would sponsor that. Now, if we sponsor it, again, that puts the weight of the planning department and the planning board behind it. When we go to, after the public hearing, we go to town meeting and we advocate for that particular change. Okay, so I know there was some confusion as to, well, who's putting these forward? What's the rationale? We don't know that until we have this hearing and we do that deliberation. So I mean, it's very general, but that's essentially how the bylaws work in our town. And ultimately, when they go to town meeting, they need a 2/3 vote. And then after they're voted on, if they pass, they go to the Attorney General's office. The Attorney General signs off on them. And the one wrinkle we have that may be of importance this evening is the fact that if we do any zoning amendments in the downtown district is a growth incentive zone. And our agreement with the Cape Cod Commission is that any bylaw changes in the downtown district have to be approved by the Cape Cod Commission. And to that point, when 2 weeks ago, when the meeting was canceled, Corinne did send the proposed bylaws to the Cape Cod Commission for their review. And they responded to us that the bylaws changes, whether they go through or not, are, in their opinion, aligned with the growth incentive zone, and they offer no objection to that. So that's where we are right now. Is there any discussion on that zone and bylaw changes, amendments, how they work? Okay, Ms. Moore?
I did want to apologize or to let the board know that I did get some questions from some board members. I did not spend a lot of time digging into them until the board, if the board decides to sponsor it, I would like to give you some feedback on it. I have some general opinions when you get into the discussion, but as far as comparison and the way they affect existing bylaws, I have not done that. So I don't want you to feel that I ignored your questions or your requests, but I didn't want to spend a lot of time on something that may or may not be sponsored by the board. If it is sponsored by a private citizen, I would make an opinion at the public hearing on that. But at this point, I have not done that.
Thank you, Ms. Moore. Okay, Mr. Clegg.
Mr. Chairman, I'd like to know, other than the wetlands change, which I assume is being driven by the natural resources or conservation people to put us in, put the town in compliance, are any other of these proposed changes being suggested by a member of the town staff, or have they come from private developers or whatever?
To my knowledge, they've all been submitted by private parties, but as each one comes up, The proponent is going to tell us why they submitted it, what they hope it accomplishes, and why they would like us to sponsor it.
Okay, thank you.
Okay, moving along. Okay, so the first, this is out, now we're moving on to agenda item number 7. This is zoning articles review. Table Downtown District 1. The first item is workforce housing. So can I ask, is the proponent of the workforce housing amendment here to speak to that?
Good evening, Mr. Chairman. Zach Basinski, Bracken Engineering.
The floor is yours.
So this article has been brought before you based on various conversations we've had with various developers through the town. We've had contractors and developers come to us to just say that they look at a project site, they would love to develop downtown, but when they look at these parameters on this, that they just can't build projects with this. And they feel it's a stop that they can't come in front of the town to talk to it. So when you look at the proposal in front of you for the workforce housing, we're just asking that it come off Main Street and that the number of dwelling units not be so restrictive to a building. Again, it would be in front of the board to review all this in front of you. But again, this is just these 10-unit housings. Some developers are looking at trying to develop it, but they look at the downtown and it just outright stops them.
Mr. Chairman, I'd like to object to this process, please.
Okay, what's your objection?
I'd like, Mr. Basinski is not a developer. Mr. Basinski is an engineer who works for Bracken Engineering. Who is the applicant on this? Because Mr. Basinski is clearly just a middleman.
And let me ask you this. Why is it important to know?
You know why it's important to know, Mr. Chairman. It all goes back to that meeting that you sponsored for yourself.
Let me rephrase the question. Okay.
Well, I'd like to answer the one you asked, please.
Why don't we?
Oh, I'd like to answer the question that you asked. May I answer the question that you asked, please?
Go ahead.
You sponsored a meeting for me and you.
We're talking about this particular bylaw, the workforce housing. Let's stay on that.
I am on that, Mr. Chairman. I am on that indeed. You sponsored a meeting for you, myself, and the McKinseys. It took place on the 30th of January. And I wrote up the meeting report about that. And you opened the meeting by saying that Mr. McKenzie has had a change in plans about all his Main Street stuff. And we went through that meeting and you said at the end that your action item, you said that Zach Basinski was going to be presenting Mr. McKenzie's requirements in order to sell that property to a major developer. And that's what you said was going to happen. And sure enough, these things came right in from Mr. Basinski. So what I'm trying to point out is that to my knowledge, and I believe this firmly, Mr. Basinski is doing this at the paid direction of Mr. McKenzie to apply to his properties. If Mr. Basinski is being sponsored by another paying customer, I'd like to know who that is.
Okay, what I would suggest is that this change would affect all properties in the downtown district.
Absolutely, it would, and that's the problem.
And
It's
as you
for the
say,
benefit of one developer, but it's going to affect everybody.
well, it would benefit more than just Vincent McKenzie. I mean, Ryan,
Why not admit to it?
it would benefit Ryan Correa too. He owns property down there too.
Well, it
would
could
benefit
affect
many
any
people.
number of developers in the downtown district. And
But-
that's the problem.
What I'm going to suggest is that we look at the change and whether it's a benefit to the town. You know, there's things that can benefit the town, that can benefit Mr. McKenzie. There's things that will not benefit the town, will benefit Mr. McKenzie. But the fact of the matter is, we're just being asked to look at this particular article. And if
I'm
we
sorry,
feel,
Mr. Chairman, I didn't trust you at that meeting with the McKenzie because of you lied to me. And I
well,
don't trust this whole process.
well, thank you. So further from the board on this amendment, are there any questions, any comments? Mr. O'Connor?
Yeah, I've got a question on the workforce housing, and maybe I need some schooling from Corinne. The question is this: the table amendment will allow apartments and workforce housing to be developed on Main Street, as well as other parts of the downtown. Does the GFL ground floor limitation mean the same thing here as it does for a mixed-use development, that is, retail, commercial uses required on the first floor? Should the GFL for apartments and workforce housing apply to all locations in the downtown? And I'll make an example here. Is it economically rational to require ground floor retail uses for a proposed apartment building on Cohasset Avenue? I realize deep in the future, we would like to see Cohasset Avenue become a secondary Main Street. But this day, short-term future, is that something we want to do? Require retail on the ground floor of any workforce housing anywhere in the downtown? Or should we say maybe limit the ground floor limitation to apartment buildings at the west end of Main Street? It's just a question. I'd like to hear if Corinne has an opinion.
Chairman, I can speak.
Sure.
My first look past at looking and reading these bylaws.
Can you hear?
Oh, Corinne, we're losing the sound.
Sorry. Can you hear me?
Now,
Right,
now.
Yeah,
good.
yeah, you're in front of the
Okay.
speaker now.
All right. So my first pass at looking and reading these bylaws would be to say, we do not want all residential directly on Main Street. I think I want to send to the board, after this meeting, a document that I have read a few times, and I think Mr. Clegg said he had never seen this document, but it was before we adopted the zoning in the downtown, the consultant did a version with commentary as to why we should adopt some of these bylaws. I would like to send that to the board so you can see the commentary, because I think most of you were not on the board when we went through that process with the downtown. And in that commentary, most of the time in your downtowns, you don't want a lot of residential. You're trying to create a commercial base. So that's why we said we didn't want commercial on the first floor. But we also have a bylaw that talks about the different layers of parcels. So you may have a large parcel that the front layer could be commercial and residential could be on the back layers, and it could be on the first floor. So I think we need to look at that a little bit further before we straight say, okay, you can put residential on Main Street. I think the back lots on the back streets of Main Street may be fine, or the back layers of a parcel that fronts on Main Street may be fine. But I think we want to be very careful before we totally eliminate the commercial on the first floor. I know at this point, residential is very hot. People want to do residential, but we don't want to make a mistake to say we want all residential downtown, because like you said, it's going to affect more than one or two parcels. It's going to affect the entire downtown. So we have been talking about that. Maybe we need to look at downtown again, because the action plan was adopted in 2008. We're now in 2021. We may want to look at this more comprehensively than without thinking this out. I just have to admit, I have not totally been able to think this out to give it a positive recommendation on my side.
Thank you, Ms. Excuse me. Thank you, Ms. Moore. Mr. Clegg?
Yes, Ms. Moore, you and I have shared information from that iteration, that marked up version of the downtown that includes the comments by the consultant. I found that to be so important in making a judgment, because that information then gives you an understanding of what the intent was behind the words that show up in the zoning bylaw. So I would ask that you send that out to everybody if possible. And also, to go back to Mr. O'Connor's question, the GFL in parentheses next to special permit here, what does that mean? Does that mean they must have a retail or a commercial on the ground floor? Or does it mean there's an exception to that requirement?
It goes to section 2822. It says that those uses that have a GFL only are allowed above the first floor.
Okay, thank you.
So that means that, yes, residential uses are intended to be above the first floor, only for the first 30 feet of the building. So if you go back 30 feet, then you can have residential on the first floor. But I think taking a look at that, I talked about lot layers instead of building layers. We may want to look at it differently.
So this proposed change is crossing out the words "not permitted on Main Street." By crossing that out, we would then be allowing residential on the second floor and above to front on Main Street. Is that correct?
What it's saying, we're allowing apartment buildings. The GFL has not been eliminated, and that may preclude what they're trying to do. Because they're saying, okay, we want to allow apartment buildings and workforce housing on Main Street. But if we keep that GFL in there, it still would have to have commercial on the first floor.
Do you personally feel that it's a good idea to have residential units on the west end of Main Street, fronting right on the Main Street? I thought that wasn't allowed.
We don't allow that now, and that's what they're asking to change. But the GFL remains there, and as long as that GFL is there, they couldn't put it on the first floor.
And what would be the rationale for change?
I would have to ask the proponent.
Mr. Bazinski?
Yeah, that was intended to be taken out. But again, just to point clarity on this, Mr. Chairman and members of the board, this is for a special permit. So again, even though if this is proposed, you still have the rights to review every project on its merits going forwards. So even if these changes are accepted and promoted, it's not like we're taking any of the abilities away from the town to not allow these or permit these things. And it's not making it by right. You guys still have the special permit approval process to review every project on it. It's just making it less restrictive for what type of projects can be brought in front of the board.
So why?
Because the developers, some of them want more into saying no more than 10 dwelling units. Some developers want to create 30, 50 units of workforce housing. And that 10 right there stops them from coming in and presenting their workforce housing.
Fronting on Main Street.
Fronting on Main Street. So again, this isn't to circumvent and take any rights away or any abilities away from the planning board. This is just to make it a little bit more restrictive based on comments that we have received from developers that have properties along Main Street. Again, you still have the right to look at every project on its merits.
Consultant said about this particular bylaw back when the bylaws were sent to the Cape Cod Commission for approval. I don't see how, I mean, I don't have a compelling argument from Mr. Brzezinski or anybody else as to why the planning board would sponsor this change.
And Ms. Brown, I'll let you go next. But to that point, again, this process, ideally, we would have met 2 weeks ago and we would have talked about these things, and we would have had 2 weeks to come back and have the planning department weigh in fully on it and really digest it. So I do recognize it's unfair to the board members to say, hey, this is in front of you tonight. Do you want to sponsor this or not? So I have to check procedural requirements, but I probably will bring these back ultimately at the public hearing. And then at that point, the board will have had about 3 weeks to do some due diligence and get the opinion of the planning department and ask some more probing questions. I think that's probably the most prudent course of action. Ms. Brown?
Yeah, I want to get back to what Corinne was saying about sort of the more comprehensive look. My initial reaction when I got these was, how does this impact everything else? And I cannot, I just can't get behind just kind of making a change without understanding the global impact downtown. And I just don't think this is a good way to do that.
And that's understood. And that's why, again, I'm not going to call for any action tonight on any of these, any votes up or down.
Okay.
Mr. Clegg.
May I have the floor?
Mr. Clegg.
Thank you. Mr. Chairman, it's more important to do this right than it is to do it quick. There is a town meeting coming up in the month of May, and as you've described, we're now under pressure because meetings got canceled, et cetera. There is also a town meeting in the fall. Is there a developer who has an immediate proposal to put in front of this board that would require this change in order to get it going with haste? Mr. Bazinski, can you answer that?
I've had interest from a lot of developers that are looking at their properties and they've stopped.
Does anybody have a project specific that they're ready, that requires this purpose, that they're ready to bring to the planning board?
They will not invest the time of developing these things until these zoning changes go through and divulging that information. They
Then I
have
think
preliminary
there's
concepts that they will bring to the board.
to have this rush through and go before a May town meeting. Do it right and schedule it for the fall. And that applies to all the rest of them, except maybe the stormwater if the town is under dire pressure because we're going to lose certification on something. Should I make a motion on that, Mr. Chairman?
Well, actually, I believe the warrant closes tomorrow. So under the circumstances, I don't see how this board is going to have the opportunity to get behind any of these. So at that point, at that
the stormwater one?
Well, it's not stormwater. I don't know what you mean by the stormwater.
You know what I mean.
The one that we have to act on is not here in front of us tonight. That's Tim Lydon is the force behind that, and he will provide that to us. I think that has to go through the Board of Selectmen as well. But that is the one that we have to have the public hearing on. These ones in front of us, it appears that if they're going to come to town meeting, they'd have to come directly from the proponent of it at this point, because I don't see how we can do it all. I just don't.
I'm referring to number 5 that deals with upland and the change to the definition.
And again, that's not what I'm talking about. What I'm talking about are the flood zone ones that Tim Lydon will be presenting to bring us to align us with the regulations. Last year, we got a pass on it because of the pandemic. It's potentially a situation where we could get fined. So that one we have to go, but that's not in front of us. It's not upland, it's not stormwater. I'm sorry, Mr. Carroll? So that one is not in front of us.
I thought you described number 5 as being an important one for the town and one that
I did not. I did not. I don't even know what one number 5 is. I have them in front of me, but I don't know what 4, 5, or 6 is.
I can't tell.
Then I'm totally confused by what you said earlier about the motivation for doing this.
Okay. So that being said, what we're gonna do, what I think is the fair thing to do is we're not gonna take any action on this. The proponents of the changes are here. They're on the agenda. I'll give them the opportunity to speak on it. But again, I don't, the board is just not gonna have the opportunity to get behind these for a number of reasons. And that being said, we'll move through them. And, you know, Zach, if you're here on a number of them and you decide that it's not in your interest to present tonight, that's fine, but I'm gonna give you that option. So, we're not doing anything on the workforce housing. Do you want to tell us about townhouse?
Mr. Chairman,
Yes.
yeah. In comment about units on Main Street and in your downtown, when I was at the different classes that was held down in Worcester, one of the main drives when I was in the classes I took were to put more residential units in your downtown to make them more diversified. So things change because the zonings that we had for the downtown 20 years ago, whatever when we passed this, and things evolve. And now they talk about minimum parking, maximum parking. So things do change. So to try to get locked into one thing or another and not adjust, I can see, let's move with the time. So whether it's now or the fall town meeting, let's be open-minded. That's all I'm asking.
Absolutely. Thank you, Mr. Doucette. So Article XX, Mr. Brzezinski, do you want to speak to that?
Yeah, for the townhouse row house, this was a change, just removing the maximum amount of buildings that could be in a unit. Again, this is a comment that has just come back. So developers want to put potentially 12, 10 units instead of 9. It's just what they look at the programming. Some lots, it's just how it looks on that lot. So that's all that change was for.
Okay. Any comments from the board, from the planning department? Okay. Okay, the next one is the, again, Article 1010 to amend the zoning map. This one, in my opinion, would represent spot zoning. And essentially, in layman's terms, what spot zoning is changing one or a few parcels within a district to a different use or zoning use that is typically incompatible with what is in that particular zoning area. So this one, again, it's my opinion that it represents spot zoning, which is not legal. If we did this through town meeting, I think the Attorney General would kick it back to us and say, you have a problem here, we can't agree on this. So on this one, I'm going to suggest that the board take no action now. And I can't imagine this coming back to us in its current iteration in a way that the board could even legally get behind it. So I don't know if you want to speak to that, Zach, but I'm pretty sure that's the case here.
Yeah, looking at those ones, Mr. Chairman, members of the board, this was just based on the use of the properties, some of the surrounding developments around them. And then it was looking at trying to change the zoning to allow for affordable or different types of housing uses in the area. So if we believe that that's spot zoning, we'll have to dive into that more and look into it.
Thank you.
And that was number 3. Is that correct? Or XX?
That was the one that read, to see if the town will vote to amend the zoning map of the town of Bourne by placing the following properties currently located in the residential R40 district into the village business VB district, or take any action in relation thereto.
I'm looking at the package from the town planner. And she has the articles presented in order. One was Article XX. 2 was, well, two 2 was townhouse and row house. 3 was mixed-use developments, building containing dwelling units. Is that where you are, or are you somewhere else?
I'm somewhere else.
It's number 6 on that list, Elmer.
Well, so when we move from one to the other, would you please make sure we're able to get on the right page?
Okay, well, I'm sorry, but my pages might have gotten mixed up, so I apologize for that. So I'll read the header so that we're all on the same page now.
I see number 6 now, and I'd like to hear, I couldn't understand what you were relating to. These are specific zoning changes from R40 to village business, correct?
Right.
Could you repeat what you said about this, Mr. Chairman? I didn't follow you.
Okay. In my opinion, if we were to do this, it would represent spot zoning, which is illegal. You cannot take a parcel or several parcels within a zoning district and rezone them to a use that is incompatible with that district. So I think this has problems on multiple levels. It shouldn't get through us because it's spot zoning. It shouldn't get through town meeting because it's spot zoning. And the Attorney General would definitely kick it back to us if it did get through those two processes.
Mr. Chairman, one of those properties is the VFW lodge.
Correct.
Is the VFW asking for this change, Mr. Bazinski?
My understanding is yes.
Your understanding. Are they signed on as requesting this?
My understanding, talking with the abutter, that's also part of this, is they want to be part of this zoning change, yes.
So you got your information from the abutter, who is Mr. McKenzie?
Mm-hmm.
Okay, thank you.
And
on,
that's actually a valid point. You can't rezone somebody else's property.
no.
So in order for this to push forward, we would need either a representative from the VFW or something in writing that assents to the zoning change. So I mean, it's flawed on any number of levels.
That same statement applies to the 2 Sandwich Road ones. Number 1 Sandwich Road is owned by some trust down in Falmouth.
Well, and again, that's why we're not moving forward on that one.
Thank you. What's
Okay.
next?
The next one I have here is to see if the town will vote to amend section 5 definitions of the town zoning bylaws by revising the definition of upland as follows, or take any action in relation thereto. Zach?
So this one is to just clarify how the town interprets their plans and their uplands, and then how they're being endorsed with total normal upland areas. So when you read the zoning bylaw right now, upland is anything that's not considered a wetland in the bylaw. So when you look at these, a lot of these plans that have been endorsed by the town, you would legally have to take out flood zones from these properties. And they would render a lot of these properties unbuildable or non-conforming in the town. Even though there have been building permits and everything issued on these lots, and if you go back and look at past plans signed by the town, it's, even though this is how it's written, it's not being interpreted this way when plans are being endorsed by the town. So this is just to correct a procedural item, and just to bring the plans into correction as to how they're being interpreted and endorsed, and how building permits are being issued on lots.
Mr. Clegg.
Mr. Bazinski, is this your wording for the change, or did you pull that from some other town's bylaws? Where'd it come from?
This is based on our experiences, and it's our wording on this, but this is based on past precedences and how the town has been looking at all these projects and these plans.
I have a follow-up question for the town planner. If this change were put into play, what impact would it have on the developable properties in the downtown district?
Mr. Chairman, through you, I did have a conversation with the conservation agent in the changing of this definition, because it definitely does impact conservation and the way they look at wetlands. We did have a short conversation today, and we both agreed that the definition should not include the floodplain. because you can build in the floodplain if you meet certain mitigation,
Right.
do that. But as far as coastal banks and what's the other thing? Coastal banks.
Land
I
subject
forget.
to flooding.
Yeah, land subject to flooding. Those are kind of iffy with me because this definition impacts subdivisions or when you're creating a lot. Under the bylaw, it says that when you create a lot, if it has wetlands on it, a definition of a wetland, it has to have at least 90% upland. So if you were to include flood zone in that, there would be a lot of unbuildable lots. So I think we agree that the floodplain probably should be taken out of that definition. Coastal banks, maybe not so, because there's a lot of definitions or a lot of setbacks that come from coastal banks. If a lot, say, was 200 feet deep and the coastal bank was 175 of that lot, you really cannot build on that lot. So you can create a lot that is really essentially unbuildable. So looking at that, we have to look at that a little bit closer. I would like to sit down with the conservation agent to see if it conflicts with conservation and how we create a lot. So, you know, I'm not ready to sign off on that because I think it impacts a lot more than just the definition of upland and definition of wetland. The conservation agent says it should be defined as CMR 13140, but I'm not quite sure what that all says. And since we're in the process of adopting the floodplain bylaw revisions, we might want to dovetail that together with that.
Ms. Moore, my eyes went to the term land subject to flooding. So I started thinking about, I was thinking first about what you described, an undeveloped lot and how that might interfere with the ability to build on that lot. But then I started thinking about, well, what about lots that are already in use, have structures on them? If we change this definition and we exclude land subject to flooding, what would happen to a developed lot owner's ability? Wouldn't his ability to build closer to an existing wetland, wouldn't he benefit from that?
You know, I can't speak for the conservation. I use this when we're looking at creation of lots. If a lot exists, we go back to the pre-existing nonconformity. Is it lawful and they would not be impacted by this and they would be allowed variances or waivers? This really impacts the creation of lots. Downtown, we now have lots that can be 3,500 square feet. If it's subject to flooding, 3,500 square feet will eliminate all those lots. But if those lots are already created, then not so. So that's why I would really want to understand a little bit more. I'm not really an expert on conservation, and I would take my recommendations from the conservation agent and how he sees that.
Once again, I don't know who's sponsoring this change. Maybe Zach knows, I don't. But I'm concerned about an existing developed lot and this wording allowing that lot owner to expand his structure into an area that previously he couldn't expand into. So I guess we're going to throw this one in the basket for future consideration anyway, but I think there's a lot to consider on this before we move forward with it. Thank you, Mr. Chairman.
All right, bear with me for a moment. Okay, the next one I have is relative to mixed-use developments, Article 1010 again. to see if the town will vote to amend section 2821 table DTD-1 of the town zoning bylaws by revising the use table to delete the identified to read as follows, or take any action in relation thereto. So this is the one that says the existing is mixed-use developments, building containing dwelling units in combination with stores or other permitted business or commercial uses.
I
Again,
can't find that unless Corinne can tell me what number that is in her package that she sent out.
Number 3.
Thank you.
Again, Mr. Chairman, this one here is just to make it a little bit less restrictive. We're requested to take out the 33% residential use per square footage and don't have that limitation on it. So it's still part of mixed use, still mixed use housing allowed. You'd still have the gross floor limitations. It also just takes out the 10% of gross floor area on the first floor should be associated or incidental. I mean, there have been projects that some people have proposed that they want a larger area on the first floor. So not limiting the amount of non-residential or residential on that first floor. Just comes down to programming that they want to bring in front to the board.
Thank you. Anything from the board? Okay. The next one I have, and Corinne, you can help me with the numbering on this, is to see if the town will vote to amend section 2821, table DTD-1. This is the apartment building. Oh, we did this one.
They already did that one.
All right, what do we have left?
The remaining one is the by right in downtown, the changing table DTD2.
Number 4.
Number 4.
Thank you, Corinne.
All right, can you speak to that, Zach?
Yeah, this is just modifying the special permit criteria to remove the density limitations. Currently, by special permit, you have a maximum density of 1 unit per 2,000 square feet for market rate housing or income housing at 1 per 15,000. This is just to remove that density requirement. Sorry, 1,500, sorry. That would just, it's requesting to remove that density requirement. It would still be anything over by right would still need a special permit, so that would still be retained with the board, but it gives the developer the potential to come in with increased density.
Anything from the board on that one? Okay, I don't have.
Sandra has her hand up.
Oh, I'm sorry. Unmute yourself, Sandra, or don't.
Thank you. I'm just listening to what sounds to me like developers are determining what our downtown is going to look like. They want workforce housing and affordable housing. All that is, there are really hot button issues on the front burner. We don't have a design or an idea of what the downtown is really all about. We've been doing this for, I don't know, since when Sandwich and Bourne separated. Used to be West Sandwich. There is no, when I say there's no plan, I don't mean that there haven't been studies done on how much residential, whatever. I hear all that. The developer comes in and wants to change something so they can make more units. Is that, the town needs to get behind what they like in Buzzards Bay. There's nothing that looks like Sandwich or any part of it in Bourne, it's downtown area. That's an extremely complex area to develop. You've got the canal, you've got traffic in various ways passing through. I just see developers controlling the whole thing. And it's piecemeal, and to me, there's no rhyme or reason to it. There's nothing, small coastal towns, I mean, I have looked at hundreds of them online and visited them. I don't see any kind of overall plan. And when I say plan, I know that, I guess I'm looking at some kind of a, is it historic? Some, not, I want to say the word theme, but something to base your design on. There's no design. Developers come in and they see an opportunity. One more affordable housing, or workforce housing, they're hot button issues. everybody's talking about having them. And they jump on it and they want to tweak the rules so that they can get more in. That's what I'm seeing. And I think to myself, what kind of a downtown area does the town want? And maybe some people aren't even, don't come over there too often from the other side. The bridges are now in flux. You don't know where they're going to go, how that's going to impact. I'm sitting here, I usually, could weigh in, and I'm thinking, this is all something that has nothing to do with what really should, the underpinnings of this area to be redeveloped. It probably never got a plan in the first place. Did you unmute me? What did you do?
You're unmuted. We've been listening to you.
Oh, good. Thank you. Enjoy it.
All right, Mr. O'Connor.
Yeah, I got a couple of comments. This one is really tricky. We're taking the back off a Swiss watch. And I think, so we're proposing that the maximum number of units per lot, which is a functional FAR, at least in terms of residential, be determined by special permit in accordance with the general design objectives in section 28, 27, 28, 38. And I got a couple of comments, and it might be helpful if you've got the section 2800 of the zoning in front of you, but I'm just going to plow ahead. I think these are all comments that are based on a certain philosophy, and this is it. I think that the flexibility to allow higher downtown density based on a clear criteria and a specified incentive structure is generally a good thing, particularly in anticipation of potential commuter rail service. But I've got specific concerns, and mostly they're about unintended consequences. The first one is the language in section 2827, that's the general design objectives, is sufficiently broad that we might expect nearly every downtown proposal with a residential component to seek a special permit for increased FAR over the by right condition. Pretty much every one. Concerned that we are more likely to continue to see piecemeal proposals for smaller parcel assemblies rather than a comprehensive development proposal based on a master plan from a large developer, perhaps due to both limited sewer capacity allocation and short-term district development economics. Specifically, I'm concerned that someone will assemble a limited cluster of parcels at the west end of Main Street and propose a single mid-rise building of 6 to 8 stories oriented towards views of Buzzards Bay and Buttermilk Bay and served by a sea of surface parking. The available development depth between Main Street and Cohasset Avenue right-of-ways varies from 330 feet to about 420 feet. That's not particularly deep when you're using surface parking. I'm concerned that the future, if we consider retail frontage on Cohasset Avenue to be a desirable goal for our future, I'm concerned that that will be precluded by the extensive surface parking required to serve development proposals on Main Street. I think maybe we should be thinking about putting some guardrails, that is an upper limit on the maximum allowable FAR, even with a special permit. The link to limited surface parking should be obvious. See section 2834. I'll get back to that in a second. I think we should consider linking revised table DTD2, DTD3, sections 2827, 2838, those are the design objectives, with sections 2834, 2837. Those are the bonus sections as they exist now, bonus FAR sections as they exist now, and also the section 2854, which allows shared parking in mixed-use developments. What I'm looking for is a coordinated approach to developing an appropriate FAR, building height, and parking capacity as part of the special permit review process. I'm concerned that this amendment might make sections 2834 and 2837 redundant or irrelevant. Let me go into a little bit of depth on that. Section 2834 offers an FAR bonus of 50% on top of currently mandated minimum lot footage per DU. In exchange for an increased FAR, the proponent is expected to provide a public good. That is, in this case, structured parking. And section 2837, some of that structured parking would be dedicated to public spaces. These sections appear to be the only current route to increasing FAR over the by right condition, and appear to be the upper limit for FAR under all current circumstances. And I'm going to ask Corinne if I'm off base there, but it appears to be these bonus sections are the only way you can get above 2,000 square foot per unit or 1,500 square foot per unit in market income housing. Those are the only way you can get above that. So if we completely take away those guardrails and say it's by special permit, I'm just wondering whether we get a piecemeal proposal where someone has assembled a parcel, says, I'd like to go to 6 levels and yeah, surface parking. So now I recognize that structured parking is a pretty rare bird. I can't think of any structured parking east of New Bedford. But my humble opinion is when you get above 4 floors, we're probably in structured parking land, or at least a single parking deck, which will allow us to double the surface parking. I'm going to yield the floor. I've got a little bit more, but that's essentially it. I'm looking for a coordinated approach between 4 or 5 sections rather than, I'm worried about a vague special permit where people come in and they like an illustration. And I'm worried about unintended consequences. I'd like to make sure we have a coordinated approach.
That's right.
And Zach, Zach, this is addressed to you. Do you think there is appetite for structured parking behind Main Street?
I do believe there is going to need to be.
I agree. Do you think the demand is there? What do you think? When do you think it starts? 4 floors, 5 floors?
Probably on some of these lots, it could be as simple as 2 floors, 3 floors, get out of the flood zone, get up, get residential. But the problem with that, it's the cost of the structured parking spaces and what it costs to build per space. So then you got to increase the density to justify that cost to a developer.
I get that. That's all I have.
Yeah.
Karen,
Mr. Clegg.
Thank you, Mr. Chairman. I have 2 things. One is a comment, one is a question. Comment first. Back on Sandra Goldstein's dissertation a few minutes ago.
Excuse me, I don't want to refer to it as a dissertation. I think that's a little.
I'm sorry. I'm not trying to insult you. I thought you made it clear.
You don't have to try. It comes pretty naturally. Go ahead. It wasn't a dissertation.
All right, let me say your message. It was very clear. It was probably the clearest you've delivered on the particular subject, Sandra.
I don't want, thanks for evaluating me. Go ahead. I've had enough.
Are your ears open or closed?
Oh, they've always been open.
Hold on. Mr. Clegg, just make your comments, please.
Okay, on the message that Sandra Goldstein delivered a bit ago, I want to direct the board's attention to that meeting report that I sent you all, that ill-fated meeting report from our meeting with the Mackenzies on the 30th of January. There was a very positive section of that discussion evidenced in the meeting report. And that was, we do have currently a patchwork development occurring throughout the downtown district.
That's right.
And Mr. McKenzie's notion is that if you're going to do the downtown district right, you've got to have a national developer come in. You've got to have an agreement between the town and that developer, or a number of agreements that allows for, and I'll use Sandra's term, this master plan with enough detail so that you have a roadmap of what do we want to see? What's our vision? How's this place going to look when we finish the development?
Right.
And I fully support Mr. McKenzie's notion of offloading his properties to a national developer, and then the town working with that national developer to develop a certain sufficient plan that will allow us to build out the downtown district in an orderly fashion and generate a result that we want rather than one that we wind up with. So that's my comment, and I commend you, Ms. Goldstein, for the words that you use. Secondly, I have a question about Dave's comments. And now I've lost my train of thought as to what it was, but I'll come back to that. I'll go on. Thank you very much, Mr. Chairman.
Mr. Carroll.
Thank you, Mr. Chair. We've used the word a comprehensive plan here. I think we always tend to avoid some reality issues in Buzzards Bay. I mean, the land is low. We don't know where the drinking water is going to come from. We don't know where the sewer water is going to go. We don't know what to do about the flood of cars. And so this comprehensive plan has got to deal with more than just how high the building is, because it's possible that we can't have the basic necessities of water once we build it. So I want this plan to take in a wider range of things than we're talking about right now. Thank you.
Mr. Chairman, I thought of my question, if I could, please.
Go ahead.
Ms. Moore, a year and a half ago, you said to this board, when I asked that we make some changes about parking to make some changes to 2800 downtown district so that we could lighten up the requirement for parking a little bit, you agreed, but you resisted and said, look, I'd like to gather some money over 2 fiscal years, and I'd like to develop a comprehensive set of changes to the downtown district zoning bylaws. Whatever happened about that? Ms. Moore.
Yes, Mr. Chairman, through the chairman.
Can't hear you.
Go to the microphone.
Again, I'm fading fast. We did do an initial parking feasibility study, which turned in that we got a grant from the state to do an overall study. Because I hate to keep blaming COVID, but yes, COVID stepped in. I just got an email the day before yesterday from our consultants that we'll be submitting the final report to that study. Remember, we had meetings, Zoom meetings with different stakeholders, with the public, with staff and people that are on boards. That report was due actually this week, a draft report. So we have worked on it. We did get money. We did get a grant. So that should be forthcoming within the next week or so.
I think what you're saying, though, that's parking specific. What I'm saying is you said you were going to try to get budget money over 2 years to do a major overhaul of the downtown district zoning bylaws. Did you not get the money? What happened?
No, we did not request that money. We were in the middle of the 2 feasibility studies. So I think the results of those studies would give me leverage to get money to do a more comprehensive look. But if the board is looking at the downtown comprehensively more than just parking, I think we need to probably request more than just for the parking issues, but for the overhaul.
That's my point.
Right.
Well, you were going to do an overall revision of section 2800 for the downtown district. And you keep, every time I ask the question, you go back to parking. I'm saying, I thought you were trying to get budget money over 2 years to do a major overhaul of 2,800.
I believe we did mention that, but you have to remember, every time a fire pops up, I have to jump to that fire. Parking was very hot for the last 2 years that they created, so that was an issue that everybody was looking to resolve, so we jumped to that. Then the next progression is to look at the entire downtown, if that everyone agrees that we can't jump from one issue to the next issue and expect to have a comprehensive plan.
I agree with you. And I think what you're hearing from the board tonight is we're backing you on a major, major review and update of the downtown district zoning.
Exactly.
Ms. Goldstein?
Parking would be, it's obvious that the downtown area has limitations. The velocity zone flood area, and there's just not the space to accommodate the density and the kinds of projects that are being proposed by developers. They're very heavy in people living there with cars. And so you need to, who's ever going to help design this, you take that into consideration. And perhaps you don't, if you don't have that much parking, you take a different tack in the kind of design, in what you want for your downtown. Do you want shops oh, we have restaurants and mixed use seems to be like everybody's jumping on it. Mixed use, apartments over something. These are not very imaginative or creative, and maybe the people in the town need to be inspired in some way by people that know how to do this. I'm not dissing anybody or diminishing anybody, but you know, specialists are out there today. That's what the world is complicated. And I think we could, you know, that's been my platform when I ran for planning board in 2017. Well, if I was able to say it before somebody cut me off or interrupted me, I just see it as not that there isn't a plan, but if you were designing your house, you call an interior designer to which walls are we going to move and how does the house flow? What's it going to look like? How is it going to live? The developers are hungry for action down there. It's an opportunity. And I think the town needs to step in and balance that out with what's we're just arguing and discussing things that should really not even come up. They should have been integrated. Those issues should have been forecast and seen ahead of time and factored right into the plan. You know, parking is going to be an issue. You just know that. I think once somebody said that they're going to put an underground parking at the West End. I thought, well, that'll take up some of the flood water. But, you know, I just think you can't, perhaps some of the lofty density kind of buildings with apartments, this and that, I think maybe they're not feasible. Maybe they're not feasible. I remember the Kendall Ray project, we were discussing that. And that's where we got into our first little discussion about open meeting law and talking about things as a group when you're not supposed to deliberate. Maybe we should have a workshop. Maybe there should be somebody who could find out who designed Mashpee Commons. They do a lot of things all over the country and the world. Maybe we could hire them and see what they could do with this area, what they would suggest. Let's get some plans that have charm and beauty as well as financial and economic development and please the people who own the properties. They may not know what to do. I'm done.
Mr. Doucette.
Yeah, Mr. Chairman, it was been stated that there's been no structures east of New Bedford. There's structured parking in Hyannis on Route 132. I was on the planning board when we discussed the zoning for downtown, and Phil Hare, who was one of our lead opponents for this, described this as one of the most progressive zoning projects east of the Mississippi. He's a professor at Harvard, and he proposed in support of this 100%. Also in that discussion was the limitations for the height to offset the structured parking for any future development for our downtown. So it's all been discussed. You know, it's nice to hear fresh discussions, but also to remember this is not the first time we talked about it. It's been a history of it, and I enjoy the debate, but also remember that it's been addressed. Thank you.
We're still arguing, we're still discussing it though. It's not solved.
I think it has been, it's just when a developer comes in and proposes an aspect of parking, our zoning addresses a lot of that, but in 20 years, some things need to be modified. So not 100%, that's why I said I enjoy the debate, I enjoy the discussion, but you can't say, we gotta reinvent the wheel. So that's all I'm saying.
Mm. Maybe it
Anything,
wasn't.
Ms. Brown?
Yeah, I do think Sandra's right in that what you want to achieve then drives the bylaws that you modify or accept or change or whatever. Those are the goal is one thing. Those are the vehicles by which the goal is achieved. You know, but if we don't know what the goal is, then we are going to go astray.
Yeah. You don't have the plan, you don't, you're fighting over regulations all the time, rather than how it ever evolved organically.
Well, there is a plan, but it's, and as Dan pointed out, it's aged, you know, but it doesn't mean that we just throw it out. But I think we could look at it and try to figure out, you know, how to make it work now. I'm done.
Mr. Chairman, I think we better look at the clock.
Okay, moving on. Anything further on the zoning changes?
Thank you for your time tonight, guys. Appreciate
Thank
it.
you.
Thank you, Zach.
Welcome. Have a good night.
Okay, agenda item number 8, these are the minutes. I'm not going to take them as a slate because I don't know if anybody has any objections. So we'll take them one by one. Is there a motion to approve the minutes of March 12th, 2020?
So moved.
Is there a second?
Second.
Any discussion? Okay, roll call vote. Mrs. Arovitz,
Yes.
Ms. Brown,
Yes.
Ms. Goldstein,
Yes.
Mr. O'Connor,
Yes.
Mr. Carroll,
Yes.
Mr. Gallo, Mr. Doucette,
Yes.
Mr. Clegg,
Yes.
chair votes yes. Minutes of 12/1/20. Is there a motion to approve?
So moved.
Is there a second?
Second.
Any discussion? On the vote, Mrs. Arovitz,
Yes.
Ms. Brown,
Yes.
Ms. Goldstein,
Yes.
Mr. O'Connor,
Yes.
Mr. Carroll,
Yes.
Mr. Gallo, Mr. Doucette,
Yes.
Mr. Clegg,
Yes.
chair votes yes. Minutes of 1/28/21. Is there a motion to approve?
So moved.
Is there a second?
Second.
Any discussion on the motion?
Yes, Mr. Chairman.
Yes.
In the process of reviewing these minutes for January 28, we conducted a hearing on the Gray Gables Market case. And the agenda item said that that meeting had been continued from a prior meeting. So I went back and looked at the prior meeting. It was earlier January, and the meeting had been canceled. But instead of, on the town website, instead of the agenda still posted on the website saying that the meeting was canceled, it said the meeting was continued to January 28th. That's illegal. And the impact is that on December 1st, we had a hearing about the Gray Gables Market case. We continued it to January, took a lawful vote and continued it. But then the January meeting was canceled. And Anne, in doing her cancellations on the agendas on the town website, always says this meeting is canceled. But in this case, she wrote in red lettering, this meeting is continued to January 28th. You can't do that. Therefore, the hearing that we had on Gray Gables Market on January 28th, which was continued until tonight, was an illegal meeting. Now, I don't want to get in the way of the Gray Gables Market situation getting settled. That's what we all want, and we want it to be settled between the two people. But once again, Mr. Chairman, I doubt that Anne would have done, made a sudden change in wording without either encouragement from you or someone else. And it was illegal. Why did you do that?
Is that a question on the minutes?
That's a question to you on the minutes, yeah.
Ian, can you speak to that?
Yes, Elmer, what happened is we were going to have a quorum issue on that date. So if we had canceled the meeting, the whole thing would have had to been re-advertised and things like that. We would have not been able to hear on the 28th. I did open the actual meeting that day. I was present on the Zoom call. It was open.
Oh,
and
wait, I wasn't there, Ann. None of us were there. You can't have a meeting without a quorum.
Let her finish. Let her finish.
It's the same thing as if in the past when we were meeting in person, if we weren't going to have a meeting, I would show up at the community building and say, I'm sorry, the meeting is continued to such and such a date. It gave everybody ample time and notice, and it was publicly announced that the meeting was going to be continued.
You cannot
That is
continue a
lawful.
meeting without a board vote. The meeting
Right.
is
So
not
I didn't
called
open the
to
meeting, but I
order.
was present. I was present and I announced that the meeting was going to be continued to the next date.
You're not a member of the board. You don't
been
have
done
the
in the
authority to make that decision. The board never convened on that night in January, 2 weeks before the 28th, the 14th. The board never convened, so you can't continue a meeting that is not held. That's just fundamental Massachusetts general law. And man, we have lost all integrity in the conduct of the scheduling, the announcements of our meeting, and the conduct of the meeting, Chairman Stroni. And it needs to be addressed and it needs to be fixed.
On the motion.
Can I just say that could it possibly be that we've spent the entire last year adjusting to an entirely new meeting process, and that maybe we could take that into account when we concern ourselves with these things?
The same
Hold on. Thank you. Thank you, Ms. Brown, but we have a motion on the floor and I'm going to call a vote for it to approve the minutes of 128. Mrs. Zarovitz,
Abstain.
Ms. Brown,
Yes.
Ms. Goldstein,
Yes.
Mr. O'Connor,
Tired of this.
Yes.
Mr. Carroll,
Abstain.
Mr. Gallo,
Yes.
Mr. Doucette,
Yes.
Mr. Clegg,
Abstain.
chair votes yes. Okay,
Oh, yay, here we are, 10:05.
okay.
Okay.
The next agenda item is item number 9. This is the open meeting law complaint relative to Mr. Clegg that I filed, I believe that was on February 10th. I'm gonna, because I did file the complaint, I think the appropriate course of action is to hand the gavel off to the vice chairman. However, I am going to remind all the members of the board that personal attacks, irrelevant attacks, slanderous statements, outrageous statements will not be tolerated. Okay? The first time someone makes a slanderous or a personal attack or an outrageous statement that is beyond what we're looking at tonight, which is the open meeting law complaint that was filed,
Very good job.
they'll be warned. I'm sorry, Mr. Carroll?
Excuse me.
They'll be warned one time. Then they'll be warned a second time, and then they will be removed from the meeting. Okay, so you have been warned that if you go off topic, you'll be warned twice and then removed from the meeting. So I'm going to hand the gavel off now to Miss Brown.
Okay. The virtual gavel has been passed to me. And so I'm just going to make some comments. What is it, Elmer? You have to unmute yourself if you want to talk.
Well, thank you. Mr. Chairman, and I'm referring to Chairman Stroni now, you just gave us a lecture about proper decorum. Did that same set of rules apply to your statements to the papers?
Okay, I'm going to make the same, I'm going to lecture the same.
Slandered by
Okay.
your statements, and now you're setting a rule that I can't say anything bad about you or anybody else when you've already committed the first sin. It's unfair that you cast a stone and then say, no more stones, please.
Okay, can we get into the discussion and then maybe we can see how it works in execution? Okay,
May I ask for a 2-minute recess since it's after 10 o'clock and I have to go to the men's room?
yep, I gotcha. Does everybody else want to do that? It's agreed to.
I'll be right back.
I've just got one housekeeping item. My battery's at 25%. This will probably cut out in 25 minutes. So
Okay, well, you know,
that could
Plug
happen.
it in.
I'm plugged in, so I could be here until midnight, but
Right,
you
I'm
know, I
100%.
understand.
I'm 100%. Keep it up.
Oh, yay, let's go on. Let's go on. So buckle in because we're going to need to complete this tonight.
Split hairs when we don't have the,
I'm going to wait for Elmer to get back. I have a few things I want to say before we start talking.
Mhm.
So I'm not going to do it now. I've also got my coffee. So let's talk at 3 o'clock in the morning then, too. Someone,
I'll be on my way to.
for her, unless she's,
Dean, I would tell you, you did a magnificent job on your review tonight. We haven't
Oh,
had-
thank you.
We haven't had a chance to see you do that in a long time, and it was excellent.
you know, I miss meeting in person. All right, Sandra's back.
Thank you.
So I'm just going to start for members of the public to explain why I'm talking and not Steve. As vice chair, I'm leading our discussion of agenda item 9, the open meeting law complaint tonight, because the complainant is our chair, Mr. Stroni. The complaint was filed against fellow board member, Mr. Clegg, following an email exchange on February 6th. I have some brief open meeting law review items before we begin. I'm referring here to the portions of the Attorney General's open meeting law guide that are most relevant to the complaint we are discussing. And I distribute this all to all members of the board. So first thing, what is the purpose of the open meeting law? We've all done the training, but let's just remember this. The purpose of the open meeting law is to ensure transparency in the deliberations on which public policy is based. Because the democratic process depends on the public having knowledge about the considerations underlying government actions, the open meeting law requires, with some exceptions, that meetings of public bodies be open to the public. It also seeks to balance the public's interest in witnessing the deliberations of public officials with government's need to manage its operations efficiently. I just would like us to not lose track of the fact that the open meeting law has a larger purpose other than just, I don't know. Okay, there are two things that are going to come up. Deliberation, please wait a moment, and jurisdiction. So what constitutes a deliberation? The open meeting law defines deliberation as an oral or written communication through any medium, including electronic mail, between or among a quorum of a public body on any public business within its jurisdiction. Distribution of a meeting agenda, scheduling or procedural information, or reports or documents that may be discussed at a meeting is often helpful to public body members when preparing for upcoming meetings. These types of communications generally will not constitute deliberation, provided that when these materials are distributed, no member of the public body expresses an opinion on matters within the body's jurisdiction. Additionally, certain communications that may otherwise be considered deliberation are specifically exempt by statute from the definition of deliberation. For example, discussion of the recess and continuance of a town meeting. To be a deliberation, the communication must involve a quorum of the public body. A quorum is usually a simple majority of the members of a public body. Thus, a communication among less than a quorum of the members of a public body will not be a deliberation unless there are multiple communications among the members of the public body that together constitute communication among a quorum of members. Courts have held that the open meeting law applies when members of the public body communicate in a serial manner in order to evade the application of the law. Note that the expression of an opinion on matters within the body's jurisdiction to a quorum of a public body is a deliberation, even if no other member of the public body responds. Okay. For example, if a member of a public body sends an email to a quorum of a public body expressing her opinion on a matter that could come before that body, this communication violates the law, even if none of the recipients responds. Okay, and last but not least, what matters are within the jurisdiction of the public body? The open meeting law applies only to the discussion of any matter within the body's jurisdiction. The law does not specifically define jurisdiction. As a general rule, any matter of public business on which a quorum of the public body may make a decision or recommendation is considered a matter within the jurisdiction of the public body. Certain discussions regarding procedural or administrative matters may also relate to public business within a body's jurisdiction, such as where the discussion involves the organization and leadership of the public body, committee assignments, the rules or bylaws for the body. Statements made for political purposes, such as where a public body's members characterize their own past achievements, generally are not considered communications on public business within the jurisdiction of the public body. The upshot of all this is they're looking for quite a bit of control and restraint on our part. Elmer, did you have something you wanted to say? You have to unmute yourself. And could you be brief?
I wanted to ask a question since you're educating the board on the public meeting law. Does the public meeting law require that if you're going to have an open meeting, that you post relevant materials on the town website?
I don't know.
I think it does. I'd like to point out to you that the open meeting law complaint that Mr. Stroni filed.
Elmer, can we do this in a structured way? Would you mind? I am going to give you an opportunity to speak.
This is not my defense. I'm asking why the complaint was not posted so the public could see it.
I don't know. Is that required? Can anyone answer that question?
I believe it is.
Well, if it is, then we'll just be cited by the Attorney General, I guess. So I think we need to continue on because the complaint exists and the Attorney General is expecting a written response. So, you know, okay. I didn't bring the complaint. I am not the source of the complaint, but we do need to discuss it. Okay. As we enter our discussions tonight regarding this complaint, our goal as a board is to determine what response we will give to the complainant, in this case, Steve Stroni, and we will be submitting our response to the Attorney General's office in writing by Monday, March 1st. This is not a general airing of grievances. Please keep your comments clear, respectful, and concise. Don't belabor points and no personal attacks, please. I'm going to begin tonight's review and discussion with a reading of the complaint. Mr. Stroni and Mr. Clegg will both then be given an opportunity to respond. We will then open the floor for questions and discussion from fellow board members. And once we determine our course of action, we will vote to approve via a roll call vote. Please note, we will not be opening the floor for public comment. Thank you all. Let's begin. I'm going to read the complaint. Bear with me while I go through the mountains of paper. All right. Description of alleged violation. Elmer Clegg, member of the Town of Bourne Planning Board, and Stephen Stroni, chairman of the Planning Board, met with a local developer on January 30th, 2021 to discuss a development project in the downtown district of the Town of Bourne. The discussion revolved around a large mixed-use project that at the time was conceptual. The developer was looking for advice and guidance in moving the project forward. On February 6, 2021, Mr. Clegg forwarded to the planning board members an email in which he included a summary report of the meeting, this email number 9 and Clegg meeting report. I'm assuming these are attachments. In this email and the summary report, Mr. Clegg opines about planning board processes, procedures, criteria for evaluating applications, and long-range planning and strategizing. Elmer Clegg has repeatedly violated the open meeting law. On April 30th, 2020, Elmer Clegg responded to an email sent to the Town of Bourne town planner. In the responding email, Mr. Clegg emailed the planning board members and shared his opinions related to planning board processes, procedures, criteria for evaluating applications, and long-range planning and strategizing. In response to Mr. Clegg's email, the town planner admonished the planning board to not engage in deliberations via email. As chairman of the planning board, I also emailed the board members warning them not to violate the open meeting law. Mr. Clegg responded to the emails by declaring that since he is not talking about a specific project before the planning board, a matter under jurisdiction, in his words, the open meeting law does not apply. Mr. Clegg has knowingly and willfully violated the open meeting law. So that is that. That is the complaint that we're considering. And I wanted to let Steve first add anything that he might choose to add at this moment.
I think the complaint speaks for itself. So I'm going to reserve any comment at this time.
All right, Elmer, would you like to present? Would you like to say?
Madam Chair, and I say that with the utmost respect, I thank you for the opportunity to present my defense this evening. Mr. Stroni, in his open meeting law complaint, and in his letter to the Assistant Attorney General, and in his statement to the Cape Cod Times, has certainly dredged my character through the mud. I take this as a serious personal attack. Tonight, I'm going to present my case. I'm going to do it in 4 sections. I'm first of all going to summarize the damaging statements made by Mr. Stroney in the various documents. Then I'll move on to the the allegations related to last April, almost a year ago. And then third, I'm going to respond to the current matter of the complaint, which is the meeting report that I circulated to the board. And finally, I will close by asking you, the board, to dismiss the charges against me.
Okay, and just please keep the first section civil. Thank you.
You have doubts that I would?
I don't know. It's been a tough night.
Yeah, it's been a long night. Actually been a long month for me. Thank you. First, I'd like to address on the complaint form itself, which Ms. Brown read. Mr. Stroney said, the Attorney General needs to intervene and sanction Clegg consistent with individuals that have repeatedly, knowingly, and willfully violated the open meeting law. That charge would have me face the most serious of sanctions from the Attorney General, including financial penalty. Stroney's clear objective here is to take this beyond the jurisdiction of this board and take it to the Attorney General. He wrote a letter to the Attorney General and attached it to the complaint. And in this letter, Stroney says, Clegg has a history of violating the open meeting law. Well, you all know my record of 8 years of service on this board. And during that time, I have never been accused of an open meeting law violation. Additionally, during my 2 years as board chair, we had no issues. Further, during my time as chair, I encouraged you board members to study local and state laws, and I urged you to get certified by the Citizen Planner Training Collaborative. I myself completed requirements for their level 1 certification, an indication that I take the laws and I take training very, very seriously. Also in his letter to the Attorney General, Stroney said, to this date, Clegg continues to violate the open meeting law. And he continues to encourage other planning board members to do the same. He's implying that there's evidence of my future intent, but there really isn't any. Then in last Saturday's Cape Cod Times, Stroney said, I really felt I had no other choice but to file the complaint. Really? No other choice? If you wanted a constructive solution, how about sitting down with your vice chair, with me, maybe the town clerk, to reach an understanding? But no, he instead took the most serious approach at hand. He went right for my throat. Then he described the situation in the paper as a distraction that is a shame and embarrassment to this board, which has many other agenda items and projects to work on. Well, truth be told, Stroney's personal agenda as planning board chair is limited solely to gaining approval for developer projects. That's my observation.
Point of order, that's beyond the complaint, and we don't need your observations, and we don't need my motives questioned on other projects. So I'll ask you to stay on point with the complaint. Unmute yourself, Mr. Clegg, I'm sorry.
You're muted, Elmer. Sorry. Can you unmute?
I suppose you had a reason for doing that. I will take.
Well, I think what we're doing is, it's a fine line between airing grievances from, you two, go together like oil and water sometimes. And I think that,
I stand for order.
we don't need to hear everything that's possibly happened. That's all. But go ahead.
Thank you.
Be careful.
I'd like to point out, since he, to the newspaper, he said that the board has got so much to do and so many projects. I'd like to point out to you as evidence that over the last 6 months, that's going back to September 2020, 50% of this board's scheduled meetings have been canceled. But he says, oh, we've got so much work to do. I just want to point out that his comments are as self-serving as they can be. So while I take the open meeting law charges very seriously and with personal accountability accepted, I view Stroney's self-serving comments to the press and his trying of this case in the press as bordering on unethical behavior. To the contrary, my comments to the press were limited, and they were limited to the following. I have utmost respect for the laws. I always try to do the honorable thing. I try to protect the interests of the community. And I would add, even when it means being at odds with a developer. And finally, I have never intentionally violated the open meeting law. I'll say that again. I have never intentionally violated the open meeting law. And I feel a need to repeat that because Mr. Stroney has said that I knowingly and willingly violated the law. Is it my word against his? Maybe it comes down to that. Let's move to the April 2020 allegations. You'll recall way back then that Ms. Goldstein had asked in public meetings for added depth to staff planning documents. She sometimes called for a master plan, which confused a few people, and I could see that it drew the ire of the town planning on occasion. One thing, though, that she was looking for was a template for the village that might express our vision and show desirable locations for different types of businesses. At any rate, the town planner grew frustrated by Sandra's comments. And finally, she sent out a position paper on April 29. That's labeled as email number 1 in the complaint package. She sent it to planning board members with numerous documents attached. It appeared to me that she hoped to bring an end, nor did they give her satisfaction. In his complaint, Mr. Stroney paints me as the first respondent to the town planner's email number 1. While he intentionally omitted this from his complaint, Mr. Stroney himself was the first respondent to Ms. Moore's email. And it was Mr. Stroney who started the chain of responses. And here's an important point. I took Mr. Stroney's first email as that he was agreeing and endorsing Ms. Moore's position, a position that I felt was inadequate. That's why in my email, which is number 2 in the complaint package, I said, thanks for inviting comment. Thanks for inviting comment. That was referring to Steve's email, and I was thanking Mr. Stroney for inviting comment. I say again, the discussion in response to Ms. Moore's email was initiated by Mr. Stroney. My email pointed out some of Ms. Moore's documents could not be opened and that none of them addressed Sandra's expectations. I simply responded to what I had been sent from the town planner without any deliberative comment. Further on, my email said, maybe it's time for a workshop. And I closed with the words, I would like to hear reactions from others. That statement referred to the idea of a workshop, but Stroney used it out of context in his complaint. Mr. Stroney intentionally avoided the workshop request, not only for me, but later in Sandra's emails as well. He avoided it because it did not serve his personal agenda. I appeal to you, board members, to rule out consideration of the April exchange in deciding on Mr. Stroney's open meeting law complaint. And I present the following justification for such action. First, if Ms. Moore wanted to preclude response to her position paper, she should have, and as she often does, she should have suggested discussion in open meeting. The town planner has far more experience with the open meeting law than any of us, and I'm sure she knows the risk of sending something out without that warning. Justification number 2. Mr. Stroney himself replied first to Ms. Moore with an evaluative statement. If anyone is guilty of transgression here, Stephen Stroney is equally guilty for abetting the dialogue. Justification number 3. My statements in email number 7 in your complaint package addressed matters under jurisdiction of the board. And my comments in that email clearly indicate that I had an understanding of the law. Or perhaps it's better to say I had a misunderstanding of the law. And those statements clearly indicate that I had no intention of breaking the open meeting law. I thought that we were just in having an exchange on an abstract idea of what level of definition is needed in our planning documents. Board members, I thank you in advance for agreeing with my conclusion on the April 2020 segment of Mr. Stroney's complaint. And I remind you that it's been 10 months since, and Mr. Stroney still hasn't advanced Sandra's topic one bit. The first discussion we've had about it is tonight. Now let's turn to the current matter of the complaint, which is my meeting report, which I sent on February 6th, relating to the January 30 meeting with Stroney and the Mackenzies. Would it surprise you to know that my reasons for sending the report as advanced material for tonight's meeting, which was originally scheduled for the 11th of February, by the way, would it surprise you to know that my reasons for sending that material were fear and a sense of extreme betrayal by Mr. Stroney? Would you think that? Would you be surprised by that? My meeting report contained information that board members had a need to know. If it contained opinions, and it did, and these violated the open meeting law, so be it. I was faced with a far more egregious situation. If I am technically at fault for an open meeting law violation, I'll accept your judgment on whether any penalty is in order. But ask yourself, why would Mr. Stroney file an open meeting law complaint over that meeting report? Well, I come up with two reasons. First of all, it contained information that he didn't want to reveal to the rest of the board members. And second, based on Vinnie McKenzie's attorney's prior written threats against me in the months of June and August of 2020, perhaps Stroney and Vinnie saw this as a way to disqualify me from ruling on Vinnie's projects.
Mr. Clegg, I'm going to ask you to stick to the facts and not your suppositions and your speculation. So I'll stick to the facts, and I'd like you to stick to the facts too.
You didn't stick to the
You
facts.
you can tell us why you sent it and what your concerns were, but you can't necessarily know what that he didn't want you to send it. I don't know how you know that.
Well, he didn't have any evidence of my knowingly and willingly violating the law either, but he drew that conclusion. And
Well, maybe, I think that's what we're going to be discussing though, right? I mean, we all have the report and the email. So we will be talking as a group about what we think about that. But you cannot make the decision for us.
I'll tell you what you don't have. And maybe I could have sent it out. I received 2 threatening letters from Mr. McKenzie's attorneys in the months of June and August.
Has nothing to do with the open
They
meeting.
bore on my
Nothing to
attitude
do with the
when I was
complaint.
set up in the meeting with Mr. And Mr. Stroney should not be speaking now.
We're gonna be here to midnight
Stroney
as we
should not
listen
be
to you
speaking now.
weave your story. It's a story, but it's a fable. Let's stick to the facts.
Okay,
and let's
the
move this on.
letters just are not a cogent. We understand that you don't have a great relationship with the McKenzies. We are aware. So just take that as a given. We know that.
I don't have issues with the McKenzies as Mr. Stroney has accused me. I take issue with some of their projects. But remember, I'm the one who gave them the solution on the ice cream stand at 100 Main Street. I did them the biggest favor they've had done in years. But I want, Madam Chair, procedurally, please do not let Mr. Stroney interfere. You are in charge of the meeting currently.
I am, and I'd like you to address, now it's time to, you started to address the part that's more current, the February. Can you continue on that without talking about your letters?
You don't think they're appropriate?
No, I don't.
You don't think threatening a letter from a developer's attorney is impacting on you?
Not on,
It has nothing to do with the open meeting law complaint.
Can you mute him, please?
I can make a point of order whenever I choose to, just like you do, Mr. Clegg.
It isn't, the open meeting law complaint is about, did you violate the open meeting law? It's not about how you felt when you did it or, who was threatening you. It's about, what you did.
I did not interrupt your reading of the complaint. I did not interrupt Mr. Stroney when he had an opportunity to comment, and I will not interrupt him when his opportunity comes again. And
Okay, just try not to drift too far from the open meeting law complaint itself. Can you do that?
I please ask that you, Madam Chair, tell Mr. Stroney to mute himself until I finish speaking.
Steve, can you please, you will have the opportunity to respond. You reserved your time.
Well, here's the thing.
Take notes.
If I need to make a point, if I need to make a point of order, I will make it. Because Mr. Clegg is doing this thing where he starts going down and he drifts off into threatening letters from lawyers. Completely irrelevant. Completely irrelevant. And we're going to be here till 1 in the morning if he doesn't stay on point.
Please take control of this meeting and mute him.
I cannot mute him. Can you please continue?
Can you please then ask him to mute himself?
I Don't know. Can you mute? Can you continue and just try to stay in the lanes? Okay, we're talking about the open meeting law complaint. You're almost there. Okay, we know you got threatening letters and that precipitated you doing this, sending the report, which was an appropriate thing to do, correct? I mean, it could have been done.
Are you judging me now before I'm finished?
I'm asking, clearly you were motivated to do it for some reason. We all understand that.
May I
Yeah.
continue? May I continue, please?
Yeah, can you get in front of your microphone? I can barely hear you.
Let me see if I can get closer.
Okay. That's better.
So I just gave two reasons why Chairman Stroni, Mike felt it was appropriate to file an open meeting complaint because I sent out that meeting report. Let me tell you how that meeting went down. Stroni called me and he asked me to meet him and the McKinseys on Saturday, the 30th of January. Steve said it was a preliminary discussion and it would be followed up by a meeting with the town planner. At the meeting, Vinnie discussed how the Main Street redevelopment was really a bigger challenge than he was able to handle. It needed to be done by a national developer.
No, it doesn't.
He identified a national developer, but he had not met with them. That company was New England Development, a large Boston-based developer, the largest in New England. And they have commercial waterfront redevelopment experience, a very appropriate national developer to look at Buzzards Bay. Hope to, somebody not muted?
None of us are. I'm not. Sandra isn't.
Vinnie hoped to sell his Main Street properties to national development, to this national developer. Vinnie said he was working with an engineer from Falmouth who had contracted with New England Development and was developing a proposal to them for a 200-unit high-rise apartment complex with surrounding commercial amenities on a 7-acre plot anchored by the Buzzards Bay Theater property with a development cost in the range of $40 million. He actually said 30 to 50, but that average is 40. Vinnie said that he had Bracken Engineering working up some zoning changes that he would need in order to make this downtown Buzzards Bay development viable. At the meeting, I expressed agreement that it would be in the town's interest to have a downtown core district done by a national developer under a master agreement with the town, rather than having the current patchwork projects that are being done. I also cautioned Mr. McKenzie that height of the main buildings would definitely be an issue with the voters at town meeting. Stroni at the meeting stated that he would proceed to get placeholder articles for zoning changes on the town meeting warrant coming up before the selectmen. Of course, I found out a few days later that he had already done that before our meeting. A direct lie by Mr. Stroni to one of his own board members. As an action item, Vinnie promised to pursue New England Development with his proposal and said he would schedule another meeting with us very soon. I understood that another meeting would take place based on Mr. Stroni's promise.
All right, again, a point of order here, a point of order. None of this has to do with the violation of the open meeting law. This is a dissertation, I heard that word earlier, on the relationship of Vinnie McKenzie in this town and his projects and his relationship with Mr. Clegg. can we please just get to
We
the
all
point
did
of the
read
matter?
the report that you sent. So
Right.
we have a lot of this information.
We
Yes,
have all.
Madam
And we
Chair.
know the meeting took place, and we know you tried to share it with all of us because you had concerns.
Madam Chair,
Yes,
I'm
11
trying,
o'clock.
I am trying. I asked for an hour. You said you'd give me
Mhm.
plenty of time.
Yeah, okay. Well, we're getting there.
Does your time count towards my hour?
I don't know. I don't have a stopwatch.
What I'm trying to explain to you and the board members is that I was under stress before that meeting, during that meeting,
Sense.
and under that meeting, because Mr. McKenzie has a history of quoting people out of context. And I was set up in that meeting. I have yet to find a viable answer as to why Mr. Stroney called that meeting. So I'm trying to point out that I was under severe duress and mental stress. Imagine my surprise when I discovered that Mr. Stroney had the town meeting placeholder articles already submitted before our meeting. Imagine my anger when I saw the detailed zoning bylaw changes sent out to the planning board on Friday, February 5th, without the meeting that Stroney had promised to have with the town planner. And imagine my panic on Saturday, February 6th, when I read the zoning changes and found out they had nothing to do with a high-rise development on Mackenzie's Main Street property.
Can I ask you a question? Do you mind about that particular
Will I
point?
finish my statement first?
Sure, I'm sorry.
I'm almost there.
Okay,
All of the changes in the zoning bylaws that we discussed tonight had to do with changes that would directly and for the most part solely benefit one or more developers' aspirations on properties all over the town. And I had been promised that we were going to have some zoning bylaw recommendations that related to a high-rise development project. That is when I decided that Stroney's meeting with me and the Mackenzies was a ruse gone bad. I decided that to protect myself and to protect the other members of the board, I had to publish a meeting report to get Stroney's true intent out in the open. So I say to you, board members, I admit to a technical violation of the open meeting law. But I plead that there were extenuating circumstances. I ask that you dismiss the charges against me. Where Mr. Stroney says that this episode is an embarrassment and a distraction to the board, I say this exercise has been the best open meeting law training any board could experience. We have all learned from it. Madam Chair, I thank you from my heart, and I would be happy to address any questions that may come from the board. But I ask once again that you dismiss this open meeting law violation. Thank you.
do you mind if I ask the question I was going to ask earlier? Steve, before you speak?
Sure.
Elmer, what is the source of your panic? Like, what did you think would happen? I'm just curious about that.
I guess primarily it was fear of the unknown. Why did Stroney have that meeting at all? There was nothing that came out of it except to give me a head fake that, hey, the Mackenzies have done all they could on Buzzards Bay Main Street, and they want to sell this to a major developer. And in order to do that, we're going to have Zach Basinski come up with these zoning bylaw changes and we're going to present them to the board.
Right, but I mean, I think I stated to you at one point, just to have a little more faith in your fellow board members, that's all. I don't have anything else to say. I just wanted a bigger conversation about that.
I have absolute faith in you and every member on this board, but I don't.
Because I think we all noted that
don't have faith in a chairman who outright lies to me.
Okay, well, let's let Steve respond now. And Steve, I'm going to give the floor to you now.
Thank you. I'll be brief and I'll stick to the facts. I didn't even intend to respond tonight or go into any, any in-depth conversation. As I said, I think the complaint speaks for itself. I don't have any, this is going to be hard for Mr. Clegg to believe, but I don't have any personal animosity towards him. I think he's done some good work for this town. I think at times he's let his personal feelings, maybe cloud his judgment, but that's my own opinion on that.
Do I have some examples of that, Mr. Stroney, or is it just words?
Again, I'm not going to get into that, but I will say this.
And I'll take it as just words.
I will say this. The only thing I need to set straight on the record is Mr. Clegg paints this conspiracy that I had trouble following it. And I still don't understand it. And please don't re-explain it again, because I won't understand it no matter how many times you put it out there. But the fact of the matter is, this board is now asked to determine if there was a violation. If there was a violation, what is the remedial action going to be? If this board cannot determine there has been a violation, then they can't take a remedial action, because if you don't know something is broken, you can't fix it. And if the board feels that there was a violation, then we need to just send this up to the Attorney General and let them then sort through it. So I'm at the point now. I'm believe it or not, I'm very disappointed that we're here today. I wish we weren't. Believe me, I take no joy in it. I take no joy. I take no joy in this whatsoever. Okay, but Mr. Clegg was warned 5 times. The analogy here is, if you get pulled over on MacArthur Boulevard for speeding 5 times, and the 6th time you get a ticket, you can't say, well, geez, I didn't knowingly violate the law. I didn't intend to violate the law. On the 6th time you've been warned, then you should know either you're disregarding the law and willfully speeding, or you just don't care. So I don't know. I don't know what's in Mr. Clegg's head. I don't know what his motives are, and I don't pretend to know those. But I'm just going to ask this board to stick to the complaint, the facts, and be done with this tonight, and send it off to Boston, and let them make the ultimate decision as to the proper course of action.
Mr. Stroney,
I'm not going to respond to your question.
In an email in capital letters in bold saying, stop the dialogue, are indicative of an autocratic style where you think you're dealing with children. I mean, you told the newspaper that you would accept a resolution to this thing, and you never sat down and had a discussion with me about it. You've never explained why you filed this complaint. You've never explained, and I need this explanation to put my heart at rest. Why did you drag me into a meeting with the McKenzies? What were your goals out of that? And then you turn around and lie to my face.
It could have been out of respect for your judgment.
I've never lied to you, Mr. Clegg, and it's offensive to me that you say that. The reason I brought you into that meeting is because you have a personal history that's with Mr. McKenzie that's bad. And I thought that was an attempt to bury the hatchet, so that going forward, personal biases and dislikes for one another got taken off the table. That's
Well,
your
the
answer.
same
You don't have to like it, but that's the answer.
Okay,
Well, the
okay,
same
listen,
person-
can we get other
the same
people's
person,
opinions and
Mr.
discussion in here? I think
Well,
we've heard quite a bit from both of you. But Sandra has something to say. Let's let her talk. Sandra?
I object to Mr. Stroney muting me while you're running the meeting, and he just did.
I just can't do it. It's just a physical reality.
I know you
I'm
can't.
sorry.
He just.
I have no way I have no way of doing this, but I would like I'd like the rest of the board to talk now. Okay?
I'm done.
I think we've heard everything, and you're not, it's not that you're not going to be able to say anything, but other people may have opinions to express. Sandra?
Okay, I've been thinking about this since I read the complaint and read Mr. Clegg's letter. I had no knowledge that Mr. Stroney or Mr. Clegg were meeting with Mr. Mackenzie. I had no knowledge or even an inkling that there was any kind of development ideas in Mr. Mackenzie's head about that.
Nor did I.
Well, no, I'm just speaking for myself. Who knows?
I just wanted you to know that. Yeah.
Well, I didn't say anybody else did, but when I saw it, I thought to myself, oh, here we go. There's no guiding light for any developer in the first place. They can think and do whatever they dream of doing and whatever. But I would like to ask here's what I thought to myself. I don't know if Mr. Stroney had this in mind or not. If a developer approaches a chairperson of a planning board with an idea and wants to know, how to bring this before the board, what do you think I should do? I wondered if I think we've done this before with other developers. If it's something that's really controversial, a little bit different and unusual from what this guy does before, did you have in mind, and of course you could say yes now, I thought maybe the routine would be to invite, never mind Mr. Clegg being there, to invite that developer, not to tell him yes, no, or whatever, invite the developer to bring his idea forward to the board in an informal presentation. Other developers I've seen that we've done that. Don't give your opinion. Don't say what you think he should do and advise him. You're both, you and Mr. Clegg, very intelligent, very, you want to take charge and go with it. Instead of telling him what he should do or what you can do, whatever, just say, bring it before the board in an informal presentation and let everybody hear it and think and see what they think. And get
what's your opinion on the violation of the open meeting law? Just curious. I understand what you're saying, and it's a good point. I'm just curious now about that.
And I also wondered why he invited Mr. Clegg. I asked him that, actually. Why did you invite him? And I thought, well, Mr. Clegg was a chairman before, and, but like I said, I think they're both very ambitious fellows, and they like to take charge of things. And we don't have any kind of a plan that the town-wide, the people who live here, just by the way.
Okay, yeah, we know, but what, can you talk about the open meeting law complaint? What is your opinion on what happened?
I can't do that.
Okay. I mean, do you think, well, was there deliberation? Is this under our jurisdiction? I don't know. Does anybody else have anything they want to raise? Okay, John.
Violating the law. I admit it.
Okay, John. That was a bad thing to admit, though. Yes.
It's not a well-run meeting.
This issue has just done more harm than any good that could possibly come from pursuing it any further. It's put one against another, that's pretty clear, among the 9 of us who meet here to work for Bourne's interests, not our interests. Any vote we take now is in effect taking sides. It would work against us in other agenda items going forward. As to the charge concerning notes of the meeting of 30 January, I asked why we would not want to hear the facts of that discussion. I understood it was a meeting between persons of financial interest and planning board members. Suggesting that it should not have been shared is counter to what we do here. The 30 January meeting appears to envision a long-range plan for the downtown district. This is a topic we turn to on occasion. more and more frequently at these meetings. It is not wrong to share the meeting notes. What we are doing with this hour, an extra hour of volunteer time centered on a personal quarrel, is detrimental to helping Bourne resolve public issues. This complaint should be withdrawn for the sake of returning to a functioning planning board. Thank you.
Thank you. Anyone, David, you need to unmute yourself.
I'm on board with John Carroll. I really think we're staring into the abyss. I've worked in places that have turned into snake pits. And believe me, the voters will sort this out if it comes to that. I've got a suggestion of a way forward. Every other time that Corinne has sent out a communication, she has said, reply to me only. Do not reply all. I think we should have tattoos. No reply all. If you've got something important to say, send it to Corinne. She'll make a decision. She has more latitude than we do. And if she thinks the group should see it, she'll distribute it. That's all I have.
Okay, that's a possible remedy that we could cite. So I could, if you don't mind, Jean, did you want to say something?
Yeah, and maybe it's as I've been on boards appointed by the town and with the planning board and not in other capacities. And I was surprised when I did serve on other boards at how much deliberation does take part via email. But as far as our open meeting laws, I was trained by taking that test, the online test, to see if I understood the open meeting laws. And so therefore, when I did start to participate and I did get reply alls occasionally, I was thrown. I thought, why is this happening? We're not supposed to hit that reply all button. That's taboo. So I have seen examples of this happening occasionally, back and forth. There have been warnings. I did search through my email and I've gone back, and Sandra and Elmer, it just seems to be, once in a while there's an opinion or something more than just a comment that goes, and it hasn't been detrimental. But this one that we're speaking of tonight, I think that it would have been great to have a summary of the meeting. An opinion was not needed. And I think in that way, as Elmer has admitted that he did violate, I don't think a financial penalty or anything severe is necessary. But, even listening to some of the conversation going back and forth and the suggestions imply that maybe we do need some more training with this open meeting law, because no, you're not supposed to do reply all. And it does lead to a habit of going back and forth. During the time of this pandemic, we're all maybe more creatures of communicating this way, and we have to check our behavior. And perhaps maybe this is a way to do it as approaching it as a group. It may be a more, we'll work together and the public will see that we can work together to overcome this. I think that would be a good outcome as well.
Yeah, I think we sorely miss personal contact, face-to-face contact. Dan, is anyone else? I can't see any other pictures. Does anyone else want to speak? Dan,
Sure.
Go ahead.
Sure. I don't know if anybody on the board has been reached by any of the two, whether the accused or the proponent of this has been reached out and try to convince them of their side, to try to plead their case. Or are we just trying to do this all in our meeting currently?
Yeah, we're trying to do it all in our meeting currently.
But nobody else has been reached by either side.
I haven't had any discussion with anybody.
I mean, I talked to them both, but not to be convinced, just to make sure I could run the meeting with some knowledge.
I would like to go back to my original thought that if Mr. Stroney had the intent, and I don't know if he did or not, to have Mr. Mackenzie come before the board, this would all been avoided. Mr. Clegg wouldn't have had to summarize anything, but I don't know if Mr. Clegg knew that he would do that or not. There's a lot of assumptions on everybody's part. But
I think, Sandra, we could have gotten those notes without opinion. That's really part of what's under discussion here.
There shouldn't have been any need for Mr. Clegg to summarize anything. That if Mr. Stroney, I don't know, maybe he was. I'm not saying he wasn't going to do it. I can't read Mr. Stroney's mind. Maybe that would be the procedure to me. I'm the chairman.
I was technically
bring it forth.
Go
Yes.
ahead. Sorry, Elmer. Yeah.
Violation of the open meeting law. I admit it. I apologize to the board. I apologize to Mr. Stroney personally, directly. You have my apology.
I think you could have handled it. I think you could have handled it. I have thought to myself that I wouldn't have minded getting that report. It's just the other pieces that were concerning. So are we anywhere near how we feel we want to, what we want to say as our response as a board? Is Mr. O'Connor's suggestion about reinforcing the way we respond on our emails viable? We all have to do that on our own. So, someone would say we could just take the language from Corinne's, but that would be a place to start. I also really do feel like there's a lot of, I don't know if it's a misunderstanding, but different interpretations of how the open meeting law is supposed to be addressed and used. And I do think we need more training. I have only ever trained by myself in front of a computer. I couldn't ask anybody any questions, and it kind of mostly just terrified me. I was like, okay, I'm going to be very, very careful about what I do. I don't know how other people feel. Would anyone be open to an additional, I don't know when we could do it or how we would do it, but we probably could, some sort of group training session? Unmute yourself, please.
Said, I'm certainly open to it, and I'll invest, and I will invest weekend time if necessary to do it.
Okay, could everyone weigh in on that, please?
I would agree. I'd be fine with that.
Sandra?
I'm not ready to make a comment right now.
Okay. David?
Yes, just fine.
Dan?
Yeah, I'm always open for training, but this is the state requirement, and that's what we do. We have to meet
Yeah.
those minimums.
It's a state requirement with a very important purpose. Louis, are you still here?
Yes, I am.
Okay. How do you feel about what we've been throwing around here?
Well, I'm trying to get my hands around the whole thing. The open meeting law, I would go for a class on it. Being a businessman in town and being on the board is always, you feel like you're on shaky ground talking to anybody about anything.
Yeah, that's a really good point. In fact, you even mentioned today you were going to recuse yourself.
Yeah,
it is confusing or not confusing, but it's concerning, and it's, there are subtleties. Yes, David.
I'm not saying how Corinne should run her business, but maybe if someone replies all, they get spanked. That might get old, but there's something about being called out professionally that gets your attention. And so if Corinne says, don't do that, you know what we're supposed to be doing.
You put her in that position, though? I don't know. I feel like part of what's happened here is that Steve has been our policeman for whatever reason, and it causes tension and animosity to constantly be reminded that you are, breaking the open meeting law. So maybe we could stop doing that if we all understood how to not do that. Right? I don't know. That's my thinking.
To get back to the question that's really before us right now, Mr. Clegg has admitted to a minor violation, a technical violation, by attaching his comments, his opinion, to valuable notes of a meeting. I think they were very, very valuable notes. And I appreciate him doing it. At this point, I think that it would be best if this complaint, if Mr. Stroney would withdraw this complaint and we let it be and let it lie.
Steve?
Well, I have, I've been called a liar tonight, a scoundrel of sorts. My integrity's been questioned. I've been called unethical. He's apologized. Oh, you're a skunk, Steve, but I'm sorry. So I will tell you this, I am not in a position right now to withdraw this complaint. Will I think about it over the next weekend? Yeah, I will. And we're not required to respond until I think it's Tuesday. And I will
Yeah, I think that's true.
and I will talk to Miss Brown about my feelings at that point. But no, I'm not inclined to, you know, I try to be the bigger man, but when your character is dragged through the mud like mine was tonight, and I believe completely unfairly, then I'm not inclined to give that person any sort of break. But
Yes, Elmer? I'm sorry,
but
Steve.
I will give it some thought, because the most important thing for me, believe it or not, is that this board retain its professionalism and do good work for this town, because in my opinion, we're one of the most important boards in this town. I sit on the school committee, which I'm going to tell you, I think that's the most important board in the town, because our charge on the school committee is to educate the youth, the future of this community. But what we do is incredibly important. And if you think that my motives aren't pure, that I don't care about this town, and this town's always been in what I've tried to keep in the town's best interest, I don't know what to tell you. I mean, I did the LCP, I did the search for the superintendent, I've chaired this committee, I sit on the school committee. I put in 40 hours, 50 hours a month for this town. And guys like him, they make me wonder if it's worth it.
Elmer, yeah, you want to pour?
I love you too, Steve.
Yeah, well.
If you were listening, when I opened up in my introductory part, responding to the things that he said in the complaint and to the newspapers, I said my reputation was drawn through the mud. So we got two hurt feelings here. But
yes, we do.
Yes. May I finish, please?
Mm-hmm.
What I'm going to suggest is that Steve, you, Liz, myself, and if you don't mind, that wise old guy with the white hair, John Carroll, have a face-to-face meeting and see if we can't come to a resolution to resolve this thing here at the board level without the Attorney General being involved. Would you agree to a face-to-face meeting?
I don't what would you?
Why would you do that?
Go ahead, Sandra.
We're having another meeting without being tied. Just a minute.
Wait. Let Sandra finish. Let Sandra finish.
God almighty.
So you're not in favor.
I don't understand. You're doing it. You're leaving half the board out. And why are you choosing, Elma, who's going to be at this little meeting? I'll tell you one thing. In your letter describing what went on at the meeting with Mr. McKenzie and yourself and Mr. Stroney, that's hearsay anyway. I wasn't there. It isn't just your opinion that was wrong to do. I mean, you can have an opinion. It should have been at a planning board meeting when Mr. McKenzie got up and spoke for himself and said to the entire board. Sometimes this board is like certain people and who they choose.
But it wasn't. It wasn't. And it wasn't because of my initiative. Mr. Stroney's the one who decided that a small group meeting with Mr. McKenzie.
You're right. I asked him, why did he invite you? I don't know what he said. I don't know what you two men are all about sometimes, but I know we don't have a guiding light for the development of the town, period. You can take that local comprehensive plan. It seems to be not working because we're here arguing about development and because there's no guiding light. And I would not, when I read your summary, I thought, well, I wasn't there. I don't know what exactly what went on. In your opinion, based on that, maybe you shouldn't have written it, and he shouldn't have invited you. He should have invited Mr. McKenzie to come before the entire board. And I'm tired of people choosing who gets on what committee. And that would be you and some other Mr. Stroney. You do it all the time.
May I speak?
Yeah.
Yeah, you don't. There's no shortage of that.
First of all, I sent that meeting report to Mr. Stroney and to you. I sent it under separate cover with words of encouragement to Mr. McKenzie. I spoke to Mr. McKenzie on the telephone before the meeting. I had an opportunity to do all kinds of research on New England development before I went into that January.
Why would you be the one to have to do that in the first place? If Mr. McKenzie comes to us and tells us about this company, we can all do it ourselves.
Hello.
You're not. I'm interrupting you for a change, right? I'm cutting you off for a change. You did that to me in my campaign in 2017, and you trained someone else to do it.
Okay, now we're really getting into it.
Yeah, we are.
Guys. I don't think we want to, I'm not hearing a lot of agreement on the separate meeting, and I'm not loving that idea. I think we can make the decision now. It's not going to get any easier or better. It's just not.
It's a lesson.
Sorry, does anyone else have anything to say?
Usurping the power.
Besides Elmer, there's other people. Please.
I'm asking.
Both of you.
Sorry, what do you say?
Yeah, they overstepped their bounds to both of them. I don't know, as I say, I don't know Mr. Stroney's plan. Maybe he was going to invite Mr. McKenzie to come before the board, tell the board what your plan is and what you'd like to do in an informal way. We'll have a discussion out in the open, no more open meeting law violation, no somebody interpreting and getting on little talks of.
Okay, the meeting we had was not an open meeting law violation.
No, I didn't.
And I guess my question is, as the chair,
you don't know.
He has the right to meet with people.
I didn't say he didn't.
I know. Well, let me finish, okay? So what would make you feel better then if he told you he was going to go meet with, suppose.
Wait a minute. Are you talking to me?
Yes, I'm asking you, other than Mr. McKenzie coming to see us in a meeting, how would you have felt if Steve had said, I'm going to have a meeting with Vinnie McKenzie, and Elmer and I are going to meet to discuss this, and we'll report back. Would that be satisfactory to you?
I don't think some people are qualified to be running this meeting this way. If Mr. Stroney, we had other people come before the board in my history on that board and bring plans, informal presentations. It's just the way you do things. And I don't care. I'm not asking anything. I'm just suggesting that was something that should have been done. And I don't know that Mr. Stroney wasn't going to do it for that matter. I really don't. I can't read his mind. And Mr. Clegg makes his summary. I think it was jumping the gun to make the summary and bring it to us. And have an opinion. It was jumping the gun. I don't want to ask Mr. Stroney, were you planning to have Mr. McKenzie come before the board and bring all that information that you all discussed, the two of you, or the four of you, or how many there were, Mrs. McKenzie and her husband, and were you planning to do that? I don't want to put him on the spot that way.
No, it's okay, Steve. Well, let's ask him, Steve. What was your thinking
would
then?
not be valid. He could say yes. Now it sounds like a good idea. He can say yes. It's not valid.
Okay.
Very much to me that the January 3rd, the 30 January meeting deserved notes, and perhaps Mr. Stroney should have published the notes or authorized some notes, because the topic on January 30th was very important to us and it deserved coverage. Maybe it shouldn't have even happened. I would go that far to say that meeting was out of line. But in any case, it happened, and it's good that we heard what happened. And I really think you're just killing us with banging this back and forth when we really need to get back to what we're here for,
which is to decide how we're going to respond.
Remember,
did we reach any conclusion there?
I made a suggestion how to respond, and if you want me to go further, I will say I make a motion to terminate debate.
All right.
And dismiss the charge.
But okay.
We're not running this meeting properly at all. It's not proper. It's not proper. And I'm not a parliamentarian, but this isn't proper. This is competitive and it's not proper.
Okay.
I don't know what went on at the meeting. You don't take notes and give the board notes. You bring the person, the live person in front of the board to explain what he or she wants. I don't want somebody taking notes. What would that do? That's not the way you do it. And I'm not a
But
lawyer.
we're not going to resolve that now. Okay,
Well,
we need to respond to the complaint. We've been asked, Steve has
I'm
been
not gonna
asked to
take a
withdraw
class.
it. He said he would consider that, right?
Taking a class in open meeting law is not the issue. The issue is whether Mr. Estroni was going to bring that developer to the board, never mind taking notes on what he said. He could listen to him and say, you know what? I think this is something for the board to hear.
I think
from
Attorney
your
General
mouth."
Maura Healy might disagree with you. Okay, we are required to respond. I agree that there's some things to be discussed around this, but that's not where we are right now.
Oh, well, I don't want to, this is just like a hollering fest with people that don't have the experience they should have to be where they are.
Okay, fine. You know what? To cast aspersions on me is not helping. Okay.
Yelling fest. You know, this is not how boards run. I've been on a few. I don't want to.
Well, that's great, Sandra. So the next, I'm not running next year or whenever the next term is. So you can get someone else to replace me. Okay. So are we, does anyone else, is there any resolution that isn't, we're just going to say, you know, we don't think it's a violation, and it is a violation. And I'm not comfortable with just saying, you know, waving it off. I'm not comfortable with that. Yes. Elmer?
Madam Chair, I would make a recommendation.
Mm-hmm.
I would be okay if the board wrote me a letter of sanction that I was guilty of a violation in the instant part of the complaint. I will
The February, yeah.
I will never agree that I was guilty back last April, because it all boils down to the definition of jurisdiction. And even the handbook from the handbook from the Attorney General states that the word jurisdiction is not defined in the open meeting law.
It does say that.
And
It does say that.
And that it's a very gray area. But I would accept a letter of sanction with a warning that if it's done again, you go immediately to the Attorney General, and I would accept that condition.
All right. Is that strikes me as a reasonable thing. Do we need any other measures? Anybody?
No.
Do you think the other things we discussed we should, so a letter of sanction is sufficient? That's where we want to go? Yes.
And the training.
And the training.
We all
Okay,
agree.
so a letter of sanction, the training, and the warning on the emails about how we do this.
I think that's pretty sufficient.
Yeah, I'm just gonna, okay, so just to summarize, a letter of sanction addressing the February complaint or the February email issue, training for the entire board together, hopefully, and the trying to put a warning on our emails similar to what Corinne does to remind us and keep us in line. That's the 3 items. That's what I would put in writing. Can I don't know. I'm not sure if I need to make a motion to do this, honestly. But I think
put it to a vote.
I'm just going to put it to a vote. Yes, Elmer.
I think you should put it to a vote without Stroni and I included.
Hey, Steve, I was thinking that you should recuse yourself from this too. Are you comfortable with that?
I am.
Okay, so we're going to take a vote without Elmer and Steve, who are the 2 parties in this complaint. Sandra, how do you feel about our proposed solution?
Repeat the proposal.
Sure. We're going to prepare a letter of sanction for Elmer regarding the February 6th violation. We are going to take steps to have group open meeting law training. And we're going to adopt a policy of trying to have warnings on our emails so that none of us take the reply all option. So we're
Is
going to
that
write that
allowed?
up and send that to the Attorney General. Excuse me?
Is that allowed? Are we allowed to do that since a complaint has been filed? Are we allowed to make the punishment here? Are we allowed to do that?
Yes, we are.
The purpose of the meeting, yeah.
That's the whole reason we do this.
Does the
Yes.
complaint have to be?
So my question is, are you okay with those 3 items as our written response to Attorney General?
It's not competing with me. It's not going to work. Do we have to withdraw the complaint? Does Mr. Stroni?
No, we do not. No, we don't have to withdraw the complaint. We simply need to respond to it. And that is the, if you don't want it, say no. If you do want it, say yes. And
I do. I just try to make something productive out of something here. I don't need more training in the open meeting law. And it doesn't seem to encompass some of the things that had they been done, this wouldn't have happened. And I don't know that Mr. Stroni wasn't going to invite Mr. Mackenzie in. I still, there's issues.
it wouldn't change, though, the fact that the way this was communicated was not within the bounds of the open meeting law.
Mr. Clegg jumped the gun on that by his suspicions.
So what is your vote then?
I'm not going to vote. I'm going to abstain.
You're going to abstain. Okay.
I don't feel like.
David?
The way this is
No.
going.
Okay. Please hold on a second, will you? Doc. No. All right. Jean?
Yes.
Okay. John?
Yes.
Okay. Lou?
Yes.
Chair votes yes. So.
Dan?
And Dan?
I got a question.
Go ahead.
Did Elmer make the motion on his own discipline?
He suggested a method of discipline.
He
It wasn't a
suggested-
motion. Huh? He said he would accept a letter of sanction, which is one of the remedies that
I
we
just,
have.
just making sure that Elmer made his motion for his own discipline, that's all. And I would vote with the board, yes.
Okay. So this passes.
What is the meeting about that they're going to have? Are you writing up a meeting that's going to take place between Mr.
No.
Clegg? No.
No,
that's not
I'm
it?
writing up a response to the complaint that goes to Steve and to the Attorney General.
Tell me
And
what
it's
it is.
required by law that when a complaint is filed,
I know.
the
it's a-
board has to meet and respond with a written response.
Right, and is there a meeting involved in that response?
No, except for our training, which I guess would be a meeting. But no, there's no private meeting involved in that response, if that's what you're saying.
Right,
Yes,
we-
Elmer?
In the way of education of one or more of the board members. The process now, after Liz writes this up and sends it to the complainant, that's Steve,
Mhm.
and to the Attorney General. Steve, as the complainant, then has the choice of accepting this board's sanction as sufficient, or he has a certain time frame, and I think it's 90 days, but I don't know from what, to say to the Attorney General, I don't accept that as resolution, and I want the open meeting law division at the Attorney General's office to do an investigation and reach judgment on their own. And that would be a panel of one or more attorneys from the Attorney General's office. So what you're doing tonight doesn't necessarily end the process. It will if Steve accepts that. It won't if he decides that this is not sufficient punishment for Mr. Clegg, and he then appeals to the Attorney General.
Yep. Or he might withdraw the complaint. So my goal will be to get the written complaint, if required, or the written response done by March 2nd. So that is, to my mind, all there is to do here. Does anyone else have anything they feel they need to say in conclusion here? Okay, good. So can I get a motion to dismiss?
Motion to adjourn.
Second.
Second, love one another.
My word choices are falling apart. Anyway,
Aye.
I don't,
Bye.
so try to relax and enjoy your evening,
Aye.
what's
Oh.
left of it.
You need a vote, you need a vote to.
Oh, yeah, that's right. Sorry. Boy, I am really losing it here. It's late. Sandra?
We're voting to adjourn, not to dismiss,
That's
right?
correct. We're voting to adjourn. I'm sorry. Did you say yes? Okay.
I did. You betcha.
Elmer,
You
Yes.
betcha.
Jean,
Aye.
John,
Bye.
Steve,
Yes.
David,
Yes.
Dan,
Yes.
Lou,
Yes.
chair votes yes. We are adjourned.